Good evening, ladies and gentlemen. Welcome to the Town of Los Gatos Planning Commission meeting of Wednesday, October 26, 2016. The meeting is now called to order. If you haven't already done so, please take a moment to silence your devices. Mr. Paulson, would you please call the roll?
Yes, thank you. Commissioner Erickson?
Here.
Commissioner Hanson?
Here.
Commissioner Hudis?
Here.
Commissioner O'Donnell?
Here.
Vice Chair Kane?
Here.
And Chair Badami?
Here. Would everyone please stand and join Commissioner Erickson as he leads us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The Town of Los Gatos strongly encourages participation in the public process with verbal and written comments. To speak on any item this evening, please complete a speaker's card located within the benches. Follow the instructions on the back of the card. Matters relating to agenda items will be heard during the itemized public hearing. Matters not on the agenda will be heard during verbal communications. This evening we have written communications, and that would be desk items for items number 3 and item number 5. Have the commissioners had an opportunity to read the correspondence? Yes. Do any commissioners need more time? No. We have a requested continuance this evening for item number 2, as requested by staff and the applicant. Do I have a motion to continue the item to January 11th of 2017?
So moved.
Vice Chair Kane. Do I have a second? Commissioner Hudis.
I second.
Any discussion? I will call the question. All in favor? Aye. Passes unanimously. In addition to their service on the Planning Commission, members also serve on various town subcommittees. Do commissioners have any reports to share from any recent meetings? Commissioner Erickson.
So if tomorrow qualifies as a recent meeting, just for the public's information, and if there are other commissioners who aren't aware, tomorrow evening the General Plan Committee will meet for the first time to consider the direction from the council on potential revisions to the North 40 specific plan. It's a publicly noticed meeting, and members of the public are welcome to attend.
Thank you for the announcement, Commissioner Erickson. That's helpful. At this time, we will move to our verbal communications. I have no speaker cards, but if anybody would like to speak to us on an item that's not on tonight's agenda, please come forward. See no one come forward? We will go to our first item, which is item number 1. Item number 1 is a consent item, and that's approval of the minutes for September 28th of 2016. Do I have a motion to approve? Commissioner Erickson.
I will move to adopt the consent calendar, specifically the minutes for the meeting of September 28th, and I had the privilege of watching a video of the meeting and compliment my fellow commissioners on their excellent work at that meeting, and I feel fully qualified to pass a motion to adopt the minutes and support that.
Commissioner Hanson?
I'll second the motion.
Any discussion? Seeing none, I will call the question. All in favor? Aye. Passes unanimously. Our next item is item number 3, for which I will be recusing myself due to a perceived conflict of interest with one of the 4 appellants. Vice Chair Kane will take over, and I will return for item number 4.
Item number 2 tonight is 19 Highland Avenue. Pardon? Oh, I got the wrong date. Item 3 tonight is 19 Highland Avenue. Thank you. This is to consider an appeal of a decision of the Development Review Committee approving an architect and site application to construct a new single-family residence and remove large protected trees on property zoned HR 2 1/2. This is APN 529-37033. This is an appellant process, and the appellants are Badami, Roberts, and Smullen, I believe. Ms. Zonowitz, I understand you'll be providing us with a staff report this evening.
Thank you. As the Vice Chair noted, an architecture and site application for the subject site was approved by the DRC in March of this year, utilizing a previously adopted mitigative negative declaration for an approved single-family house on the site. The DRC approval was appealed, and in June, this commission considered the appeal, continuing the matter and recommending the applicant consider revising the project in light of their comments. The direction included primarily reducing the size of the house and the extent of retaining walls, reducing development outside of the LRDA, and increasing the setback from the top of bank. A revised project was submitted in July. A note regarding the environmental review of the project: an addendum to the adopted MND, which is Exhibit 30 in your packet, was prepared for the revised project, including a brief explanation of why, based on the evidence, a subsequent MND pursuant to CEQA guidelines is not required for the current proposal. The Commission continued the matter to this evening in order to allow consideration of a recent CEQA case cited by the appellants in September, and in response, the addendum has been revised to specifically address the relevancy of the MND to the project. We have this evening the town's environmental and biological consultants available to answer questions as well. So regarding revisions to the project, briefly, the square footage of the house and its footprint, as well as the overall length of the house, have been reduced. The bulk is reduced by setting it further into the hillside, especially as viewed from the neighbor's driveway on the southern edge of the property. Changes to the driveway also reduce the extent of the retaining walls. And then shifting the house to the south means it continues to fall outside of the LRDA, but it increases the minimum setback from the top of the bank to 20 feet. As the town has purview over development, as the Commission is aware, as the town has purview over development for adjacent to creeks, based on the specific site conditions, exceptions to the recommended 20 to 25-foot setback for slope stability may be allowed with geotechnical studies, which is the case in this project. So this evening, we're recommending the Commission should consider whether the revisions adequately address your directions from June. Thank you.
Thank you, Ms. Zonowitz. Do we have questions from staff? Commissioner Hudis.
Yeah, starting with an easy one. We had an Exhibit 38, and we also had an Exhibit 32. Are they identical to each other? Because I read everything, and I was trying to compare.
I think there was a revision to 32 in Exhibit 38. That was it was a correction, essentially, in that exhibit.
Okay, could you call our attention to that? Because it's kind of difficult. There's probably 50 pages in that exhibit.
You're looking at the September 14th staff report?
Well, Exhibit 38 is dated received 18 of August 2016, and Exhibit 32 is dated received 18 of August 2016.
So, Commissioner Hudis, in the staff report that contains that, Exhibit 38 is a revised version of Exhibit 32, which includes some attachments that were inadvertently left out of Exhibit 32 when it was originally provided. And so there's some additional exhibits is what the reference is called to.
Exhibits to Exhibit 38 or additional pages or?
To Exhibit 32. That was corrected with Exhibit 38.
Okay. Okay. I had some other questions about the CEQA, particularly for the attorney. I wonder if this is appropriate time to ask.
Yes.
So we have two questions here. In the staff report, it states that the addendum to MND addresses the questions that were raised. But following that, in our desk item, there's a long letter that talks about the court case. And I don't see anything in our staff documents about that court case. Could you, what is the importance of that court case? Is it relevant? And why isn't it addressed in the staff report?
So with regards to the addendum, after our last meeting, we looked at the Friends case and what it required us to do, and we went back and we made changes to the addendum. And the changes that were made had to do with when there's a proposed project change, as is here, the town must determine whether the previous environmental document retains any relevance to, in light of the proposed project. So you have to make some findings about the relevancy of that previous EIR, of the mitigated negative deck to the proposed project now. And so those changes were made in the addendum so that it would comply with the Friends. I didn't address the legal arguments regarding that were made in the desk item, but I certainly can right now because, quite frankly, they're absurd. They do not comport to what the Friends case said, and I can cite you specific language to the Friends case. But in a nutshell, what they're trying to claim is the fair argument standard applies now based on the Friends case, and that court didn't say that. That's what the plaintiffs were trying to argue in that case. But that court specifically says the fair argument does not apply. The substantial evidence case applies. And I can cite you where it says, and I'll quote, plaintiff argues that application of this substantial evidence standard to projects initially approved via negative declaration, which is right what we have right now, creates a loophole in the statutory scheme allowing agencies to evade their obligation to prepare an EIR based on more demanding fair argument standards. That's exactly what the appellants are trying to state, that this case states. But the court said plaintiff's argument would have the force if the guidelines did, in fact, create such a loophole. But the substantial evidence test referred in the guidelines does not. The court then went on to state it would be absurd to require agencies to restart the entire process of environmental review from scratch each time the agencies proposed any change, no matter how minor, simply because the project was previously approved by a negative declaration. So it's quite clear that you do not apply the fair argument standard. You do the substantial evidence test. So that's why, I mean, I don't know why they're coming up with this argument, but it's just, it's not what that case states. I can cite you throughout the whole case where they go into it, and it's a substantial evidence test. So I looked at it from what we needed to do legally to meet that requirement in the addendum. We did that based on attaching the relevancy to the two documents, but I didn't do a whole brief on the fair argument test because I just, it's very clear and didn't need to do that.
Mr. Schultz, when you say Friends, you're referring to the social name for the Supreme Court case
Yes.
that we are waiting.
Yes.
You get ahead of guys like me, and I don't know.
Yes.
It's a good TV show.
It's the
That's
San
why I
Mateo
remember.
case. Yes.
So this is a Supreme Court case that we're waiting for.
It came out and just a few days before the last one, and so we continued this hearing so we could take a look at that. And we did, in fact, we made changes to our addendum based on that case. And so that's why I thought we had resolved that issue, came forward with the addendum, and then obviously the appellants are making an argument that the fair argument standard applies, and all you need to do is find any fair argument to require an EIR. In this case, said no, you have to find substantial changes, is substantial evidence that the proposed project has new significant impacts. And
Okay.
the addendum did not find that.
Mr. Hudis, I interrupted you. You have other questions?
No, just as a follow-up to that. So there was the original letter that initiated your research, your legal research, and then there was a desk item that came in, I think, today, dated October 26, which is comments to October 2016 addendum. And I just, to my simple mind, it seems like someone is setting the foundation for litigation, either with another party or with the town. And so do you feel that it's important to address this in writing, perhaps after we've
Not
made
at all.
our...
Not at all.
Okay.
It's a legal argument that if they did want to file on that basis, I'm confident we would prevail, but it doesn't need a written report to that. We've done the analysis, we've done the addendum. If it would have to go to an appeal to council, maybe at that point in time, a written argument, but the case is so clear on this issue that I'm surprised it's being raised. Now, there are other issues in the desk item that you need to address as a planning commission on whether the applicant has
I understand.
has met your previous requirements before they came back. So that issue is for you to decide. But as from a CEQA standpoint, we've met our requirements under CEQA. The CEQA document can be approved, and again, like we discussed in our workshop, CEQA documents can be approved because they meet the CEQA requirements. But you could still find the project doesn't meet your guidelines or your zoning or your general plan requirements.
I understand. My questions really only pertain to points 1, 2, 3, and I believe 4 of the letter that we received today.
And I believe they had to do all with the fair argument, fair
Correct.
standard argument, which we've met.
Okay, thank you.
So I have a question for staff on that very letter from Smullen, Badami, and Roberts. It's the letter that precedes the discussion of the Friends case, which was an addendum. So that's being set aside in my question. In that letter, argument is made as to whether or not the applicant has responded to the Commission's guidelines. Now, staff's report was favorable to the applicant regarding compliance. And I'm wondering if you could answer the question, was there anything in this letter that gave you second thought about that initial opinion?
I think the staff report addresses the changes that were made, and it's, again, up to the commission this evening to decide whether or not those changes meet the direction that the commission gave the applicant. There was nothing in the letter. I mean, I could speak to the points in the letter, but I don't think it changed the conclusions or the information provided in the staff report.
Thank you. Other questions for staff? Commissioner Hanson.
I had 2 questions. One was just a quick follow-up on the discussion about the Friends case. I actually went and read the legal opinion online, and I didn't know if I interpreted it correctly, but it seemed as though that the court came down and said that the court would defer to the local agency in terms of determining whether or not there was a substantial event that required additional analysis. So it very much supported the opinion that you just gave us, right? Okay, so that was one thing. The second question I had was, because this has gone on through several hearings, I was going back and trying to determine what the appropriate document was to determine what findings we need to make. The original document we got talked about compliance with CEQA, and then there was when we looked at it in August, there was an update to the findings, but I never saw where there was the addendum included because that was new as of September. So I didn't know if there, and we didn't get with our current staff report a new findings document. We did have additional revised terms and conditions in August 24th. So
Right.
if you could just guide me to what we should be looking at to make our decision.
Right. They would be the findings that were provided to you in August. But in addition, we would, should you want to approve the project, we would have additional language to put into the findings for CEQA this evening. And I can give you those at that point if you like, to essentially to consider the addendum and state that it was prepared in accordance with CEQA and add that into your CEQA findings.
And the terms and conditions, the conditions of approval, if it were to be approved, are the ones that we got in our August 24th staff packet.
Correct.
Which included some of the issues with the biological issues and
Correct. Some project
and all
conditions.
all of the mitigations that were in the MND. Okay.
I have 47, 48 exhibits on the case. Could you remind me which exhibit that was for the conditions of approval? I've got 37 in my head, but I don't know if that's right.
It's 26.
26. So that's the sheet we'll be working off of if we get there.
That's what I just heard. Is that correct?
26 of the conditions.
Thank you.
And then the findings are 33.
Other questions for staff? Seeing none, I'll invite the appellate to come up and talk to us for 10 minutes. And please ensure I've got necessary speaker cards. God bless you. Do I have a card for you, sir?
No.
Well, you can give me a card when you're done. Just give us your name and address before they start the timer.
My name is Anthony Badami, and I live at 1 Highland. I thought we were on the docket for the second item, and Lisa Roberts is not here, nor is Dee Dee Small in our team. Was there a change in the agenda?
No, I believe you're item number 3.
Oh.
So we had a consent calendar. We had the minutes. We had a consent calendar on a continuation, and then you.
Okay.
Well, hang on a second. We're going to move forward. So in a moment, you will have 10 minutes.
Okay. So I stated my name, Anthony Badami. I live at 1 Highland. The motion at the June 8th Planning Commission meeting was to continue the public hearing in order for the applicant to work with neighbors and consider design modifications. So how did that go? Well, in working with neighbors, the developer essentially presented a take it or leave it proposition for us. The design modifications, in a nutshell, were de minimis. This is a summary of the changes as submitted by the developer, and I will touch on each of these throughout my presentation. At the meeting, the June 8th meeting, the Commission directed the developer to design a substantially smaller structure, and substantially was emphasized. The response was to increase the height by 1 foot, decrease the FAR in the single-digit range, and decrease the length by 2.1%. That 2.1% represents 26 inches on a structure over 100 feet long. The 20 to 25-foot creek setback was deemed credible. There are 6 to 16-foot structural setbacks in multiple areas. There was advice to attempt to comply with the LRDA. The developer went in the opposite direction, increasing the breach from 34% to 40 to 45%. There was advice to read and follow the Hillside Development Standard and Guidelines. There are still multiple violations. There was much discussion on reducing the retaining walls. The astonishing amount of retaining walls was reduced to still an enormous amount. And when you add in all retaining structures, that 200 figure jumps up to over 400. There was advice to fit into the natural surroundings. The bulk, mass, and volume are perceptually unchanged. There was sage advice to fully validate the old CEQA. That was rejected in favor of a flawed addendum. And lastly, to work with neighbors, the neighbors' input was rejected. So let's go into the details of that. The Commission guidance to work toward an LRDA compliance. The developer went in the opposite direction, increasing it from roughly 33% to 45%. The breach is occurring in Area 2. The more appropriate area for an LRDA breach is in Area 3. There would be less hit to the trees, less hit to the road, and less overall visual impact. And yes, it can be done. This is taken from the town's consultant. The number of retaining walls, the length went from 210, it was decreased to 210, but if you include all the retaining structures, the house foundation and the walkways, which are effectively acting as surrogate retaining walls, it jumps up to over 400 feet. The rear yard retaining wall doubled now to a net 10 feet. That is worse. Grading is worse. The rear elevation now completely cuts into a 36% grade. That is a patent standards violation. And this photograph, I don't know if you can turn the lights down, Joel, maybe. Well, this photograph highlights and emphasizes the standards violation, and I think I was being rather conservative with the 36% slope. Grading at Creekside, there is an enormous amount of fill that is occurring precariously close to the top of bank, and, quote, it is not the preferred option because placement of fill in riparian areas can damage streamside resources. That fill will create a height differential from pavement to creek of 10 feet, and the drop-off is sharp and in certain areas violating the 2-to-1 guideline. This photograph, Joel, well, this photograph emphasizes the impact of grading at the creekside. There is a 10-foot height differential. The sharp slope occurring precariously close to the top of bank. There's still potentially excessive tree removal, maybe worse. 38 mature trees potentially will be destroyed. The developer states that only 7 are planned for removal, but when pressed, he admits that another 3 are nearly certain to be destroyed, and there is another 9 that are of questionable survival. So that is 19 trees, which is more than the previous plans. The starred trees here represent a tree cluster that is marked or at peril for destruction. This will have a significant and, in secret terms, a substantial impact with road stability, with privacy, with the overall visual character, with tree canopy coverage, with light entering the riparian area, among other things. This view is from the Smollins perspective, and those starred trees would be replaced with a 2-story side yard wall plane extending over 100 feet long, hugging the road. The photograph on the left was taken 1 week prior to our last June 8th meeting. The creek is alive with water, with thriving vegetation. 3.5 weeks later is the picture on the right. This is after all the discussion we had on the creek, preservation of the natural environment. It appears that a strategic clear cut of only the driveway and turnaround area occurred. The entire understory was removed and dumped into the creek. And this is a patent fish and wildlife violation. The developer acknowledges this. Why did he do it? And these photographs emphasize the targeted clear cut. Whatever the reason for the clear cut and the weed abatement excuse doesn't hold water, the issue now becomes one of grading restriction. If there is no obstacle to the top of bank, then there is no grading restriction. It's not the preferred option, but it's allowable. However, if there is an obstacle, i.e. vegetation, well, you just simply remove the obstacle, and now there's no restriction, and a grading baseline has been established, albeit in violation of code. The setback conflict issue is still unresolved. There are the same concerns, but worse. There is no street presence with this house, and it is now much closer to the road. This photograph demonstrates the relationship of the story poles to the road, and actually these story poles should be much closer to the road, but because the house had not changed substantially in size, the developer was not required to readjust his story poles, so he didn't. The setback is 10 to 15 feet from the road. The side yard wall plane soars 2 stories and extends over 100 feet long, 10 to 15 feet from the road. There's been a specious attempt to comply with the creek setback with creative cantilevering and a crafty levitation of the building pad. But when you clear the smoke, there are multiple structural setbacks at 6 to 16 feet, violating the 25-foot stream mandate. This is a site plan with an overlay, and there's over 160 linear feet of encroachment, and that is in contrast to the addendum, which states only a few areas of encroachment. Lisa Roberts wrote an eloquent dissertation on CEQA. She is supposed to be here tonight, and hopefully she will make it in time. The driveway issue is worse now. There is the overlay. There's not one but 2 driveways. They are less than 20 feet apart, extending over 175 feet long. And now there's an impractical driveway turned around. There is no way that a decent-sized vehicle will be able to smoothly back up, turn around, and nose out of this driveway. Instead, vehicles will be forced to back up this curvilinear driveway 175 feet long. That's not going to happen. Cars will be forced to park in the fire turnaround, defeating the purpose of the fire turnaround and obviating the need for all that concrete poured in the valley next to the creek. Here are the multiple violations. Alternatives exist. They were ignored. The architecture should blend, be respectful, and compatible. And compatible is just not house size, which was the only criterion mentioned in the staff report. Architectural compatibility is also important. The neighborhood is defined by historic and traditional homes. Placing a contemporary home in the midst of all this shows no connection with these homes, is incompatible, and inconsistent with the guidelines. The maximum allowed height issue is still unresolved. That's because there's an existing grade discrepancy. The topography was altered to meet height limitations. And now the developer refuses to provide the existing grades for these cut sections on the revised plans. Why? This needs to be cleared up. The general plan states, as a standard, a maximum of 2 stories shall be visible from every elevation. Elevation here refers to an orthographic projection. It does not refer to wall plane. Clearly, there are 3 stories visible here. In the north elevation, clearly there are 3 stories. And there's a possibility of a stacked 3-story, but we don't know because the developer refuses to provide the existing grade for this cut section. Does the building form reflect the hillside form? No, it does not. It abruptly cuts into the hillside. Yes.
Thank you. Is it Dr. Badami?
Yes. Yes.
Thank you, Dr. Badami. Could we have lights, action, camera? Thank you. Questions for the speaker? Commissioner Hudis.
Thank you, and thank you for the very clear presentation. I had some questions that are a little further down in the presentation, and maybe you could go to the slide on FAR. There's no slide number, but there's a table. It looks like it's a few slides ahead. It just says FAR, and then there's a table on it.
It's coming forward.
Yeah, keep going. There's a lot in here, so. Keep going. Yeah, that one. So I'm trying to understand the argument of, that it's one of the largest contiguous mass, most constrained, and I'm trying to evaluate the FAR objectively, and I'm looking at a neighborhood where there's a lot of variability in lot size. I mean, every lot size is different here. So to me, FAR becomes pretty important as compared to just looking at the size of the residence, because some of these are on enormous lots, and some of them are on lots that are considerably smaller. So that's where I rely on the ratio, the floor area ratio, to me, to help with neighborhood compatibility. So I'm looking at these, and it looks like there are about 19 properties on the table, and 12 of the 19 are the same or larger FAR. So is my conclusion correct that this proposed property is in the bottom quartile, in the bottom 5 out of the 19 or so?
Bottom 5 as far as size?
In terms of floor area ratio, looking at that column where it says that the revised project is 0.09. I mean, this is your chart.
I see that column.
And so when I look at 0.09 and I look at the others where 3/4 of them are a larger floor area ratio, that tells me that this is in the bottom quartile of floor area ratios.
Yeah. I think it's important to take note that this table erroneously includes cellars in the total square footage. So that, to me, would have a direct effect on the FAR. So I think it's an inaccurate and actually misleading table. I don't think you can take valuable information out of this. I think you need to compare apples to apples, not apples to oranges. This is a house that has no cellar. It's a contiguous mass, unlike many of these homes, which are broken up masses.
Well, I can ask staff, because this was a staff table, but you've included it in your presentation.
Correct.
I can ask staff whether that causes an inconsistency, but the conclusion that I'm reaching at looking at this is that this is not one of the larger homes in FAR compared to the others that are here.
Dee Dee will comment on that.
So
Okay.
I'm one of the applicants, or one of the appellants, sorry, representing the Smolin family. And the problem with looking at this FAR exclusively is it doesn't take into consideration the topography of the lot and the constraints of the creek. So whereas some of these lots don't have the constraints that this 19 Highland has, so it would be really, you're looking at it in complete vacuum.
Right.
Based
Could
on
you,
the
could you
site.
state your name and address, please?
Dee Dee Smolin, and my address is 15363 Peach Hill Road,
Okay, thank you.
Saratoga. I'm representing the family of Smolin at 25 Highland.
And you'll give us a speaker card later, please.
There are 17 properties on that far chart. Of the 17, 9 are not even zoned the same as this property is. There are one as opposed to Hillside. So they have no relevance whatsoever, as far as I can see, in terms of this particular property on the hillside. Secondly, the vast majority of those homes were built many years ago, including, for example, my home, which was built in the 1940s and then remodeled in the I think it was 90s, under entirely different sets of rules. Mine, for example, was prior to the Hillside Development Guidelines. And I recall, I believe it was Commissioner Hudis last time who commented that, or no, excuse me, Commissioner King, who commented that it's not helpful to compare this property to properties that have been approved under entirely different sets of rules.
If you're responding to my question, maybe you could state your name and address, please.
I'm Lisa Roberts. I'm at 78 Alpine Avenue.
Okay. And I don't know if you heard my question, but it was specifically about FAR. It wasn't about other things.
No, and I'm sorry. I didn't realize we were going to be switched, so I apologize for being late.
Okay, thank you. I don't think you were switched. I think you're item 3. So, thank you.
And give us a speaker card later on. Thank you. Other questions? I'm going to turn to the original. Oh, we have a question. Didn't see it. Commissioner Hudis.
Yeah, I'm not sure who this is for, but this is regarding, let's see, Exhibit 32. And there's it looks like these pages are not numbered. I apologize. So it's 1, 2, 3, 4, the 5th page, which is titled Neighborhood Meetings. And there is a question that's raised about an easement and whether the easement is consistent with the actual access road. And I wonder if you could provide some further information. It's item 5 on that page. It says the Smolins use this easement for egress to access their home at 25 Highland. We spoke about how the current paved road is not at all where easement states it is. I expressed my concern about this. She said she would look into it. To date, she's not contacted me in any way concerning this issue. Are you aware that there's an issue of where the easement is and where the actual access road is located? Okay, could you explain to me what's going on there?
There is a discrepancy, but I'm not sure why the applicant is so eager to address it. It's been in that same place. The road's been in the same place for probably, I don't know, maybe Derek knows, 50 years, longer. The house was built around the turn of the century, so the road has never moved. And when I looked at it, it didn't help him any to align the easement with the road. So it was it didn't change what the setback would be. It didn't give him any more space. And it's something we can take care of. It's not a problem. It's just not an issue. So I'm not sure why he's bringing it up.
Okay, but my understanding is that the applicant is living with a situation where there's a road for someone else's benefit that's not located where the easement says it should be.
Right, correct.
Okay, thank you.
And it's not relevant to the setback. So he's only bringing it up to say that we're not being responsive. And we will, if he's really eager to do it, we can change the location, but it actually would make his setback harder to achieve.
Oh, I ask him as well. Thank you.
Other questions? I have a couple, Doctor, if you'd return to the mic. In your presentation, you said the revision. Now, by revision, I mean what's being presented tonight and what was presented last time when we gave them, I think, 4 considerations to take a look at. You said that the revision, as opposed to reducing size, bulk, etc., the mass of the house, that actually the height had increased?
Yes. Yes. And I can show you on a table if you'd like.
Give me a reference for that. I thought it went down.
No, it did not. Oh, was that it? No. Oh, it's way down. But I do have a table, and it enumerates all the levels.
Well, that's okay.
Well, it's easy. I got maybe 2 more, 3 more. And it's very clear. It's a clear table.
Staff can probably address it for me. Let me ask you another question. You were discussing the retaining walls, and on one of your exhibits...
there it is, if you'd like to. I'm sorry.
Overall height?
So I looked at the revised plans and the original plans, and you can take a look at the plans yourself.
I'll find it.
Okay, this is what I pulled off.
Thank you. You were talking about retaining walls and said that there had not been much of an improvement consistent with the guidelines that we gave them. And my understanding is the retaining walls, because the whole house has been shifted, were reduced from 653 feet to 210 feet. That seems to be a significant reduction.
And if you include the house foundation and the walkways, which now are effectively acting as surrogate retaining walls, and the point here is that the house is not smoothly going with the slope. It abruptly cuts in to the slope, so it's a 90 degrees. The house cuts in and it's straight at 90 degrees. So that's an effective retaining wall, and the walkway is a retaining wall. I mean, you put steps on top of a retaining wall, and you call it a walkway, and now you obviate the you call it not a retaining wall. That doesn't make sense.
I got it. Thank you. Other questions? Commissioner Hudis.
I'm concerned, as I was in the previous hearing, about the setback from the creek, and you have some different figures than what the applicant has. One of the figures you mentioned is 160 lineal feet of encroachment. Could you explain that to me? Is that the driveway? Or
the driveway takes the bulk of that, and that is a structure and should be included. I think there's roughly 30 feet of house structure that's included, maybe more.
Okay, because I'll address that with staff in terms of the definition of structure, and I am concerned about the driveway as well. So I appreciate your clarifying that for me so that I can understand what that 160 feet is comprised of. Thank you.
Other questions? Seeing none, thank you. I'm going to invite the applicant to address us for 10 minutes, and hopefully you have your speaker cards.
Good evening, Commissioners. It's good to see you again for this project. You're familiar with the history of the site and the project. It's been before you 3 times. It's been before the town several times before this. As you know, it's a somewhat contentious project because of only 3 appellants. Often attention is given to those who speak the loudest, not necessarily buffeted by facts or reality. This graphic represents the more quiet, yet equally valid support of the project. And some of these folks are here tonight to talk to you. Also here are several of the experts, as well as some of the peer review experts, to speak to the technical details should you have questions. You've seen this. This is a diagram kind of stating what the 2016 DRC approved proposal was, and then modifications made to the project based on the last Planning Commission. Of significance, we have a 9% reduction in the overall floor area, reducing it by 429 square feet. The footprint is reduced by 21 square feet, 21% reduction of 620 square feet. The lot coverage is reduced by 13%, an overall reduction of 905 square feet. Creek setbacks have been increased to the 20-foot minimum plus, and at the driveway from a minimum stated prior of 3 feet to a 10-foot. And we do have a driveway slide later, Commissioner Hudas, if you've got questions related to driveway grading. This is a significant reduction. And just continues kind of the attempts we've made to handle the feedback. Grading is up. This is mostly due to snuggling the house into the hillside to further comply with hillside design guidelines, and then also we lowered the footprint of the house to reduce the overall bulk and mass in terms of its finished floor level relative to the site conditions. Retaining walls have been reduced by 68% from 653 feet to 210. Tree removal has also been reduced. There are approximately 90 trees on the site. We're proposing to only remove 7. We do believe that we comply with hillside design guidelines. We went through these before. We can go through them again. Locate buildings within the LRDA. This is something that's of question because we have a very complex LRDA on this particular site due to the shape, the slope, and the creek. Preserving views of highly visible hillsides. Obviously, we are not viewable from any Los Gatos viewing platform, and neighbors' views are quite clearly protected, and most neighbors can't even see this property from their home. Protecting riparian corridors. Per EDS and the town peer review biologists, this is not deemed a riparian corridor. Protected wildlife. There's no protected wildlife officially determined on this site, and per hillside design guidelines, we're upholding the no fencing policies so that deers and squirrels and whatnot can meander through and visit the creek, etc. Chris is here tonight to speak about the percent of the slope. As you know, the LRDA suggests that we want to have a 30% slope or less, and it clearly states, and it's in the blue diagram here, that it shall be avoided unless no other alternative site is available, which is what we've kind of tried to do here. And let's see. So this is a diagram of the LRDA. I think what's important to understand is that technically speaking, the LRDA is actually the green area. The pink area is the 20-foot, pink dash line is the 20-foot creek setback. The dashed black area is the slopes less than 30%. Property line is obviously this, and the kind of green-blue line are relevant to building setbacks. So when you do all that and you overlay every single one of those items, the green area is the area of LRDA. You can tell from our proposal we actually sit within that significantly. Slope in the LRDA. While there are areas in the LRDA that are less than 30%, the average slope of the building footprint in the LRDA is over 30%. But only by 2.6%. I'm going to let Chris speak to slope stability.
So briefly touching on slope stability with regards to the creek setback. Per the town guidelines, there are 2 different criteria for the creek setback. For slopes that are or for sites that are located in zone not R1, it's the greater of 20 feet inboard from the top of the bank, or it's a ratio of 2-to-1 slope measured from the bottom of the creek bank. Within R1 zones, if the lot is less than 10,000 square feet, this same criteria applies. If the lot is more than 10,000 square feet, it's a 25-foot setback from the top of the bank. To note from our project here, a 2-to-1 slope from a 3-foot high creek bank would relate to a 6-foot setback. The current proposed is a 20-foot structural setback. And also of note, we are zoned in the HR 25. We're not R1, so the 20-foot ratio should be the maximum to apply. These guidelines were created to minimize impacts to the streams. In reality, there's actually no magic number associated with 20 feet. From a geologic perspective and from a biologic perspective, the 2-to-1 ratio is much more of a adherence that should be applied to. If a 2-to-1 slope works for slopes that are 10 feet high or more, it should also work for 3-foot high or slopes that are less than 10. In conclusion, I mean, based on the geology, the footprint, all the foundations for the building are going to be in bedrock. All the foundations are outside of the 20-foot creek setback line. There are portions of the house that are cantilevered within the 20-foot setback line, but they do not touch the ground within that area. We akin this to a diving board hanging out over a pool. The pool water can move, and it has no impact on the diving board itself. The diving board itself can flex and move. It has no impact on the ground. The proposed configuration meets the town's 20-foot setback. It substantially exceeds the 2-to-1 slope setback, and there are no slope stability concerns within the creek bank area from the house.
This is just a reminder of the visibility of the proposed home from the appellant's top left slide shows along the private drive, not a road, as does the bottom left photograph. The far right photograph shows the minimal netting that can be seen from Ms. Roberts' property. Okay, what we've done this time to help address some of the issues that were brought up in the last meeting, we've rotated the house footprint further into the portion of the hill here. You can see in order to pull back from the 20-foot creek setback. We've also changed the footprint. The current proposal is the red line here. The March DRC approval one that we saw last time is the green footprint. The previously approved, obviously, 2010 one is the blue one. You can see there's a significant difference when you look at the creek setback, and we've kind of tried to follow the line of the creek with the building footprint more graciously. Floor plan comparison. I'll just jump right into each floor plan. Orange shows the previous submittal you saw. Black shows our current proposed submittal and the reduction overall of the footprint in different areas. Main level footprint, we have pulled the house in on both sides to reduce the length, pulled the house in also on the other sides. And this does make for a skinnier house, but it does overall reduce the bulk and mass. We've shifted some of the areas from the private road hillside to the other side in order to further handle some bulk and mass. Again, the upper level has been reduced by 7 feet 10 inches on the Smullen side and 4 feet 6 inches on the initial driveway access side. Elevation changes. I do believe that your feedback last time did net a better house this time around in terms of us reducing the bulk and mass from a wall plane perspective. We shifted a lot of the roof lines around and broke up the overall bulk and mass by having some of the cantilevered areas. You can tell the previous proposed and the current proposed elevations show how we're more buried into the hillside. We are lowering the roof lines at the private drive side. I know that the appellant believes we're not following the hillside design guidelines because of this one roof line that's here, but I'd like to argue that that actually settles it down along the private road and makes the bulk and mass smaller to them as they drive by. The entry tower was also reduced and brought well inside the overall mass of the home. Again, you can see from the private road, we've brought the building down and introduced cantilevers, reduced windows for privacy, etc. Same on the creek side. Again, reduction in windows, broken up more with more roofing that comes around, and moved the building in and out on each floor to one another in order to change the bulk and mass and have no shear wall panels. It's a diagram of cantilevers if you want to talk about it.
Thank you. Questions for the speaker? Commissioner Hudas.
Thank you. A lot of material here. And I'm trying to understand the reductions that have been made to the house. It looks like the main thing that's been accomplished is the pullback from the creek. Is that correct?
I think the pullback from the creek and the overall reduction in length and massing of the home.
Okay. So the question I had was really almost the same question I had at the June 8th hearing. And I understand we have challenges with the LRDA, but it seems to me part of the reason we have challenges is because we're making the size of the house a given. Have you done the exercise to look at what size house could be accommodated with complying with LRDA? Did you do this exercise at all? And what size did you come up with if you did?
Okay, so let's see. To reiterate, technically, the LRDA is only the green areas here. I don't know. Velimir, can you do a quick takeoff based on the drawings of what the square footage of one of those areas might be?
Could you repeat what he said? And
He said he doesn't.
And give us his name, please.
Velimir, he's a civil engineer on record.
And he said?
And he said he doesn't know exactly the area, but it's very small. You can see from the site, it's tiny little areas. So in order to fit in the actual LRDA and then also comply, you can see the organic shape of this. The building isn't organic by nature. So, I mean, I would suggest that if we were to fit within one of these pockets based on scale, we'd probably be at a home that's less than 1,000 square feet. Because by the time I meet height requirements, bulk and mass in a three-dimensional way, it's impossible for me to fit, as you can see, and have a room. I mean, think of this site. The site's very long and narrow. We have almost a credit card kind of house already in that it's slot driven on the house. Room sizes already are at kind of almost a code minimum. Our upper bedrooms are 10 by 10. Code minimum is 9 by 10. It's not an excessive sized home.
Okay, thank you. I mean, I reached a similar conclusion that to comply with LRDA, you'd have to make a house that's about a third of the size of what you've proposed, or maybe even less. And that seems to be about the number that you're coming up with.
Right, and I think the driver on that does indeed have to do with, the enhanced slope stability, as well, the enhanced creek setback, as well as the average slope kind of thing. So those comprise it. But I just want to remind you that it says shall be avoided unless no other alternative building site is available.
Right, I understand that. Thank you.
I do want to, if you want to kind of understand the house on a partial portion of the property, Ed has made a model here so you can kind of see it maybe more realistically in terms of an actualization. The model is in white. The topos are the cards. The green pins indicate existing trees to remain, and the red pins indicate...
Excuse me, Bess. Is it heavy?
No.
Pardon me.
Okay, so the driveway's on there. The topography is on there. The model is a 3D printer model of the CAD file inserted in there. The green pins indicate existing trees to remain. The red pins indicate proposed trees per the approved landscape plan. I'd encourage you to kind of get down on it eye level and look at it from the road so you can actually see, what you'll actually see from that is a better understanding of this. This is what you see from the private drive. The private drive of the homeowner, Ed, and his fiancee, Cindy, not the developer, the homeowner. This is the most impacted view corridor of the property.
I'm going to assume we have an answer. Yes. Did you have another question? Let me interject one while you organize. One of the prior speakers said that in this revision, the height of the house was increased. Now you're saying the sides have come in, and when they came in, did it push up?
The sides have come in on the house, and no, the height has not increased. No.
Is it the same or is it less?
We dropped the foot actually 18 inches on half of the house and stepped it down. This is part of what increased some of that grading that occurred as part of foundation grading. And you can see in the okay.
Commissioner Hudis?
So I had some questions about the driveway, and I guess the first question is, why shouldn't the driveway comply with the 20-foot setback?
Well, the first thing about the driveway is that it's not a concrete driveway, as was spoken before. It's permeable pavers. It's going to allow infiltration and surface runoff and everything natural process to get to the creek. It's not a constricting structure like a poured concrete driveway would be.
Will there be less displacement in constructing the driveway than there would be in constructing the foundation of the house?
Absolutely, there would be. There's much less the excavations for this project and the grading on this project is to excavate to set the structure into the hillside.
Okay, and is your reading of the code that a 10-foot setback is permissible for a driveway?
Yes, it is.
Given that I believe we're coming to the conclusion that this is an intermittent stream.
Yes, it is.
Okay, and then the other question I had was about the driveway. Have you looked at any alternatives in terms of moving the driveway further away from the creek, maybe eliminating the bulb out that is just adjacent to the garage? I'm looking at G4 of the plans, or locating the turnaround for the fire trucks to the south side of the driveway rather than the north side. Were those alternatives that you considered that would cause the driveway to actually be further away from the creek than it is now?
So prior development plans looked at that and were run by the fire marshal. The fire marshal was unsatisfied completely with that. Also, it was discussed, could we share a driveway turnaround with neighbors in order to almost eliminate it altogether? Again, the fire department said completely no. And what was approved and worked on with them was the current configuration that you see today. And that is what they deemed as permissible. We do know from civil studies that had we flipped it to the other side, it would have increased retaining walls. That's part of what one of our original issues was. And it would have impacted the site in terms of a grading and overall height matter in a worse configuration. The civil engineer came up with another alternative. Hold on, here he is.
I'm Velimir Sulic. If you move this driveway toward the existing driveway, you create a hazardous driving conditions because you will have a retaining wall to support lower driveway, but then you will have to build another retaining wall on a top driveway so the car doesn't go over. So you will have an upper driveway, retaining wall, lower driveway. So it's very hazardous condition.
Okay, thank you. And then I had another question, which was about the bulb out, referring to G4 of the plans, and it appears that there's a portion of the driveway that gets close to the creek. Looks like it's just west of the garage. Can you put, is it possible to put G4 up there?
I'm not sure if I have the G sheets on here, but we'll see. Hold on. I don't have the G sheets on the PowerPoint. Mm-hmm. Here, let's put it right on here. We don't know how to work the technology of the town.
G4 of the plans. So it's, I don't know what the plans, Exhibit 27. Yeah, what I'm talking about is that portion of the driveway that gets close to the creek, that sort of bulb out. Yeah.
Talking about this one? So
Yes.
The top of the bank line is here.
Yes.
You can see from a relative 10 feet, we're more than the 10 feet away.
Right, but I'm wondering if it's possible to leave even more space there to be more consistent with the 20 feet, at least for that portion of the driveway.
We need this area so the car when gets backs up so they can turn around and go up the driveway.
I see. So it's not possible to back out of the driveway, so that bulb out is required to make a K-turn or something like that in order to get out of the garage.
Yeah, so we've complied with the 10-foot setback for the garage from the creek by creating a place for this space to back up and then pull out the driveway.
Okay, thank you.
Velamir has good-looking hands.
Commissioner, have a question?
I had a question. The appellants made a comment that they didn't feel that your design had done what the hillside design guidelines asked for, which is blending into the hillside, and it wasn't flagged in our staff report, but I just was wondering if we could hear maybe from the geologic perspective and your design perspective how you've fit the design into the hillside. And I also was a little concerned about the comment that they made about this big, huge wall coming up by the road. I mean, I thought you would just have the road and then the lots kind of down from there. I don't know why anything would be protruding up over the road. And
It's not. I'll show you a section.
Okay.
Joel. Okay, so how we fit into the neighborhood first, or how we fit into hillside design guidelines?
I was referring more to fitting into the contour of the hillside, because there's actually a diagram in our hillside design guidelines. It's like, do this and don't do that. And they were saying you're doing the don't do that instead of the do this. So, and it was following the contour of the hillside.
Okay, so I think probably of most significance is their one diagram that says our roof lines are going the opposite of the direction of the hillside. And you saw that in their presentation and guideline. And what they're referring to, as you can see here, is the section cut of the grade and this particular roof section that's here. We also have a little bit of it previous. We've modified and brought the rest of the building down in this direction here. So if you look at those diagrams in the hillside diagram, they say this, not this, and they've got kind of a very actually modern, rustic, contemporary home with shed roofs. Most of the roofs do indeed go in the exact direction of the hillside. That's a nice sketched diagram. We have taken that and tried to accommodate that for the most part everywhere where we can with our footprint from a geometric perspective. So you'll see that we've got our major roof pitches that pitch toward the creek do indeed kind of flow in the direction. This was obviously prior. This is proposed. The one that they bring up the most in terms of their specific statistical diagram is this piece of roof right here. This does go opposite the slope. There's a reason for that. If you look at the overall height, if we went with the direction of the slope, we would actually have a bulkier, more massive, taller building. It's our architectural choice to make sure that we actually shut down to the road, providing privacy both to those who pass by on the private drive, one family, and then also to protect the home for our owner. If you look at, let's see, If you look at this elevation, you can see here's the kind of height of the grade at that, and then this is our roof. If we had continued to pitch up relevant to this, obviously, geometrically, you would have been taller. So we chose not to. I think this diagram helps to illustrate that. This line is indicative of the grade at the building wall itself. You travel further up the hill, take a close look at that model. You'll see that what you see on the private drive is actually only this portion of the home. Had we pitched this roof in the direction of the hill, you would see more of a sheer wall, and we wouldn't be in compliance with the two-story wall design guideline. We felt it was better and a more appropriate architectural response for that particular roof member to go in the direction that it does. I believe it reduces bulk and mass and protects privacy for everyone. If we look at the section cuts of the home, exactly per the hillside design guidelines, we're bringing the house into the hillside. Of course, there is a 90-degree cut. That's how you build a foundation. People don't have the slopey walls that follow the slope of the house. Again, this is indicative of the road is up here. We're sloping down. We have the foundation of our house. This is what you're seeing in that other elevation from this section cut. Again, from the road piece, we do have our main roofs coming down in the direction with the slope, and it's portions of them that are counter to that. We've made a tremendous effort to really shift the bulk and the mass in terms of the floor plan and the roof lines in the house to be responsive of everything.
Okay, thank you.
Commissioner Hudes.
Thank you. My last questions are on trees and bioswale. I want to make sure we get the tree count correct, and it looks like there were a few different ones. I'm referring to the tree inventory assessment. Doesn't seem to have an exhibit number on it. Maybe it's part of Exhibit 32. I think it's the back pages of 32 or 38, since they're the same up to that point. And I want to make sure we get the tree count correct, because I may ask for some things relative to this. So my understanding is that there are 86 additional trees, existing trees, that 6 will be removed, that there are 22 that have to be protected, and that leaves 58 when you do that subtraction, and then there's one more tree that is in poor health that you're proposing to remove, so that there will be 57 that are not affected and 22 that are protected. So that's 79 trees remaining. Is that correct?
So my name's Richard Gessner. I'm the consulting arborist that drafted that report. So there was a little bit of confusion in the original report that I drafted, because I included trees that were on the adjacent property. And then I was asked to remove those trees from the report. So those were taken out, and that brought us to the 86 number. Or I think that's what it was, about 86. And then the new proposed plan, I believe, removes 9 trees. Is that 7 trees? And then there's other trees that are close to construction that would need to be protected during construction. So the way that it's stated in the report is that you have trees that are highly impacted that are within the footprint of the proposed plan. Those trees have to be removed. Then you have trees that are close to the proposed plan, which would require some protection during the construction process. And then beyond that, you have trees that won't be affected at all.
Okay, but I'd really like to verify the number that we're dealing with.
So 7 will be removed.
I know, but I'm concerned about making a good count of the existing trees, before and after. So, and the remaining trees. And so I just want to make sure you're representing that there will be 57 plus 22 remaining,
That's correct.
which is 79 trees?
That's correct.
Okay. Thank you. I had a question about bioswale, but I can...
Go to Commissioner Hanson.
I actually had a question about the trees. I had the same question as Commissioner Hudis about the accuracy, but I think you answered that. But then I looked at this model, and you said the green pins are the trees that stay, and the red are the ones that are being removed. But there's way more than 7 red pins on there. So help me.
Red. So green are the trees to remain, and red are the trees per the landscape plan that are replacement trees that are also put there for privacy and protection along the road. So red is new, proposed trees per the landscape plan. Green are existing to remain. 31 new trees planned to be planted per the landscape plan.
Okay, so that doesn't have a representation of what trees are actually being removed.
No, those are in the way of the model. We couldn't put them on there. They'd be inside the building.
Commissioner Hudis.
So there was I believe in the revision, there is a reduction of bioswales from 5 to 3. Is that correct? And what's the reason for that?
The reason for that is because we reduced almost 432 linear feet of the wall, so we don't need any more sub-drain behind the wall to concentrate water, and we reduce the size of the roof. And only what you have to justify, pre-construction runoff versus post-construction runoff. And difference is only 0.04 CFS per second. Then you multiply that by 60 seconds and 10 minutes for duration of 2-inch rain, unbelievable rain, okay? You are getting only 24 cube feet for 10 minutes. And we have right now 80 feet of bioswale. And if you take section of bioswale, 7-inch deep, gives you 2 square feet times 80 is substantially more than we need. Hydraulic calculations shows that we need only 12 linear feet of the bioswale, but we have 80.
I see. And that's represented by 3 separate bioswales?
That's represent that all the water for 1 hour continuously runs at 2 inches per hour. That would take this all water.
Right. But the construction is for 3 discrete bioswales?
It's 3 bioswales.
Okay. Thank you.
Other questions for the speaker? Seeing none, thank you. I'll invite members of the public, if you've turned in a speaking card, and Ms. Weisman will need speaking cards from your team as well later on, ones I don't have. Any speakers from the public? Then I will turn back to the applicant and give the applicant 5 minutes to chat with us further.
Applicants go first.
Oh, applicant, excuse me. Starts with an A.
Are we Sir.
Thank you, and good evening, Commissioners.
You're speaking for the applicant.
I am.
Then let me explain what just happened. We have no public speakers. So the applicant will now get 5 minutes, and then we will conclude with 5 minutes from the appellate. Sir, you are?
I am Bart Heckman. I'm the Land Use Counsel for the applicant. And I wanted to address some general points, really, that were referenced in the Commission's dialogue at the last full hearing and have been touched on a little bit at this hearing. The first is that bulk and mass is generally an important planning tool because it protects neighbors from negative visual impacts. But here, the appellants never identify even one personal impact to any of them from this house as currently proposed, or even as previously proposed before the revision. Not in more than 30 minutes of testimony over multiple hearings, and not in more than 150 pages of written materials they submitted. None of these three appellants will see more than a little piece of the roof from their homes. That's the most they'll see. The only neighbor who will see a substantial part of this house from his home has written a letter of support. Now, the town's ordinances suggest that bulk and mass are not an issue, or at least not a significant issue, for structures that won't be seen. For example, basement square footage is not included in the calculation of square footage of the house because basement square footage can't be seen and it has no effect on bulk and mass. It's hidden. Here, this house has a beautiful design that is highly articulated, as Bess has explained. And there's no change that could be made that would reduce any significant visual effect on any neighbor that's complaining, because it doesn't cause any significant visual effect on any neighbor that's complaining. So what I'm suggesting is that there's no legitimate reason to change the design of this home in this location based on bulk and mass concepts. Next, I want to address statements to the effect that Mr. Pearson is trying to maximize the development on the site. First, I want to point out that maximizing allowed size does not conflict with the rules. By definition, it complies with the rules because it's the rules that set the maximum. Here, the parcel is 45,000 square feet. Under your codes, that would allow a house of up to 9,300 square feet. But your codes also include a provision that penalizes property for slope. And applying that provision, this parcel is treated as though it was less than 20,000 square feet and can only have a 4,700 square foot house plus a garage. The house proposed is 452 square feet less than that, and that's a lot. So we're not maximizing the size of the home here, and in part that's due to the Commission's comments and urgings and the response of the applicant. But the point I'm trying to make is that when people talk about the need to reduce the size of the house due to site slope constraints, there needs to be a tempering recognition that your code already does that, and it does it in a way that is applied fairly and evenly to every parcel in the town. I do want to remind the Commission that LRDA stands for Least Restrictive Development Area. If the Town Council, in adopting the Hillside Guidelines, had wanted to limit construction to that area, it would be called ODA, Only Developable Area. But it's not. And it's clear from the guidelines that development outside the LRDA is not prohibited, but rather the effect of the regulation or the guideline is to encourage applicants to use the LRDA first before looking to areas outside the LRDA, and clearly that's been done here. Finally, in the letter that was submitted earlier today by the appellants state 5 times that the applicant or the town or sometimes both have conceded some statement that appellants made in one or another of their earlier letters by not expressly disagreeing with that statement. So I'm here to say on behalf of Mr. Pearson that we expressly disagree with all 5 of those statements, and I suspect that the town staff does too. Thank you.
Thank you. Questions for the speaker? Commissioner Hudis.
I wonder if you've had a chance to read the desk item that we received today, dated October 26, particularly the comments to the October 2016 addendum, items 1, 2, 3, and 4 that were the subject of our discussion earlier with the town attorney.
I have.
As someone who practices in this area, what's your opinion of the relevance of the Friends case, and if it has relevance, how would it affect this particular application?
So the Friends case is directly relevant, and for that reason it was appropriate for the town to take the actions it took. But before the Friends case, there were certain rules in place under CEQA for what you do when you approve a project with a negative declaration and you come back later after the project has been approved and make some changes to it. So there's a set body of rules. And the first addendum that the town staff prepared followed those rules. But the Supreme Court case, which happened to fall just before the last hearing, changed the rules. It required a new finding by the local jurisdiction based on substantial evidence that the prior environmental document, in this case the mitigated neg deck, retained relevance. It still retained some informational value in light of the changes that were being proposed. That requirement never existed until this case came out. It's not anywhere in the guidelines. So the state Supreme Court created new law. So that was a finding that had to be made, but it wasn't addressed in the first addendum because nobody knew that you had to make that finding. So as I think reflected in your environmental consultant's letter and in the addendum itself, they went through the analysis to determine whether that old mitigated neg deck still had relevance. And frankly, not surprising to me, since this house is about 95% the same as the old house. I'm just making up an estimate, but mostly the same. It still had relevance. It's roughly in the same place. And a lot of the changes that have been made actually are reducing environmental impacts. So that was the first change that was made. And it had to be addressed in your document to make your document legally correct under the new law. And that's been, I believe, done. The second change that the state Supreme Court did was it sort of reframed the question you ask once you've decided that the old document is relevant. And you frame that question, and I'm not going to I don't have it up here, so I'm not going to try to quote the law because I'll misquote it, but it's framed around the changes. You're going to, the focus, since you've already looked at this project once, the only question before you is whether the changes that are now being proposed from what you already looked at and approved, have those changes created some new environmental impact that you didn't study before because the change didn't exist. So, and again, the revised addendum looked at those things. It needed to, and it responded. So, does that answer the question?
Yeah, it's very helpful, at least to understand your position on that. I had one more question, but happy to let others.
Any other commissioners have questions? Go ahead, Commissioner Hudas.
I'm not sure who this is for. Someone on the applicant team. The question was I raised with the appellant about the discrepancy between the easement and the actual access road location. And I wanted to ask the applicant whether there was an issue with that and whether that's something that we should consider.
I think I can answer that. I think and I haven't looked at either Exhibit 30, wherever that statement came from. I think it was just sort of a statement of fact that where the private drive to the Smullen home is located doesn't sit wholly within the granted easement, but it doesn't affect the design of the house, and we're not suggesting that condition somehow be remedied as a part of this.
Okay, so the applicant is okay with where it's currently located?
Yes.
Okay, thank you.
Other questions? Before we decide that we're done, I want to ask a question of one of the commissioners. Commissioner, you asked earlier about the do and don'ts that were in the appellant's letter that we received as a desk item today, where they show a picture of a house in the hillside guidelines and then the revised house.
Yes.
So that's like on pages 20, 21, 22 of the letter because they're not numbered. Did you get a satisfactory answer to that?
Yes. I also noted before I asked the question that that there was nothing in the staff report that indicated that they had violated anything in the hillside design guidelines in terms of architecture or grading. The only issue that I saw I guess what we can ask the question again when we close the hearing, it was that they are outside the LRDA.
Okay, thank you. Then I don't have a question. So I will turn to the appellant, provide 5 minutes for you to provide additional information, rebuttal.
I'm Lisa Roberts. Given the shortness of time, I will make this very brief. With respect to the CEQA issues, Mr. Heckman overlooked one final finding by the Supreme Court, and that was that when the prior declaration or document is a negative declaration as opposed to an EIR, the fair argument standard applies thereafter. They have not applied the fair standard argument. Number two, with respect to neighborhood support, I see the house from my property. I see the house from my upstairs. I see the house from my backyard. I also see the tree that will doubtless die when this property is built. It is not correct that all these trees are being retained, because as I set forth in my tree report with my August 10 letter, and then again with my August 24 letter, which has never been denied by applicant, the tree protection measures are substandard. They're contrary to those they're stated as being standard in the arborist report by the applicant. Finally, with respect to neighborhood support, the chart that you were provided is incorrect. There's a large vacant lot. You will see that is also on the opponent side because it's owned by the Smullins, who are opposing this project. In addition, one of the supporters has now sold his house. He was in the process of selling it when he gave his letter of support. He's now sold the house. Third, with respect to the appellant, Ms. Teresa Spalding, who has withdrawn, she has not done an affirmative statement of support. She has simply withdrawn. I can see how someone would be tired of fighting after a while. Thank you.
Questions for the speaker? Or not at this point? You're continuing. Sorry, Doug.
So I'd like to go over the summary changes that the developer submitted. Number one, I stated the building footprint reduced by 620 feet. That's deceptive. And the red shows the square footage that was not included. And the analogy here is that if you have a 1-foot pedestal supporting a 5,000 square foot house 2 inches above the ground, is the footprint 1 foot or is it 5,000 square feet? The total floor area reduced by 429. That's not substantial, and the developer admits that. The hillside guidelines are clear. Ensure that development does not dominate. This development dominates. It is an oversized structure for the site. The trees are removed, decreased from 15 to 6. That is false. The developer flat out acknowledged to us that another 3 are nearly certain to be destroyed, and there are a questionable 9 that may not make it. Trees closest to the creek will be preserved for creek bank stability. That's an overstatement. T8 will be retained. T13 has questionable survival, and T16 will still be destroyed. There's only 1 tree for certain. Retaining wall length decreased from 653 to 210. If you include all rotating structures, that jumps over to 400. And the rear yard retaining wall is a net 10 foot now. That is a Payton standards violation. The house footprint reduced by 610. That's a redundant statement. It's a filler item. The house recessed into the hillside, it's suggested by the guidelines. Here is the example. And the Pearson development. It's textbook perfect for how not to set into the hillside. I'll go back. Do this, don't do this. Textbook perfect. How not to set into the hillside. Distance from tree 30 to building footprint increased from 15 to 20. That's an incidental finding, and again, it's a filler item. The overall height, massing, and length of the home has been reduced. That is false, worse, and trivial. The height has increased. The overall height, the original home was 444 feet. It's now increased by a foot to 445. I don't know where they're getting the inches, but these are on the plans. The massing is worse because the house is much closer to the road now. The creek setback has been increased from 15 to 20 feet from the closest point of the home's footprint. The slope stability protection area is an area between a structure and the stream, not footprint. There's over 160 linear feet of encroachment. So if we look at the summary here, the design modifications, they lack meaningful changes. Some are deceptive, some are worse, and some are just patently false.
Thank you. Questions for the speaker? Commissioner Hudas.
This is a question again about the letter dated October 26, so I'm not sure who that is for. But it starts with a comment. It says that neither the letter from Kim Lee Horn nor the October 26 addendum were made available to the appellants before end of the day on Friday, October 21, 2016. And I'm concerned about that and the ability to respond. So I wonder if whoever wrote that could respond to that.
I will respond to that. I made it clear right after this hearing was continued from the 28th. I made it clear with town council that I would like to discuss anything that occurred after that. I did not learn that what was going to happen until finally last Wednesday, I sent something to town council saying, I haven't heard or received anything, or I presume there's not going to be a new CEQA related document. So is the hearing going forward? The response was, yeah, the hearing's going forward, and I'm working on the CEQA related document. Hope to get it out today. Next day, I send a question, status. I'm hoping to get it out today. I send an email saying, well, all right, I probably don't need to ask this. I'm sure you do this anyway. But as soon as it's done, would you please make sure I get it? I got no response. So I did not get that until it was publicized with the staff report. So basically, Friends came out on the 19th. I submitted a letter on the 22nd, fully analyzing it. A 23-page letter over a 20-page case. And I applied it to this case. A month goes by. I've never seen any written analysis, legal analysis, either by staff, town council, applicant's attorney. I haven't seen anything in writing. But I see an addendum, and so again, I'm able over the weekend or with 2 business days to come up with the little I could. The October 26th letter, or
Okay.
excuse me, 20.
So I'm specifically referring to what happened on Friday, October 21st, last Friday.
Yes.
My understanding is that the letter was published as part of the agenda packet at around mid-afternoon on Friday. I know that's when I received my packet. Actually, that's when I went online and read it. Was there a problem?
No.
You're not able
no.
to access it on the internet or something?
No, I'm sorry. That differential would have been my fault. As between I didn't know it came out at the afternoon. I received it or got it late in the day.
Okay, so you did receive it on Friday?
On Friday.
Okay, thank you.
Other questions for any member of the appellant's team? Seeing none, thank you, sir. I will close the portion of the public hearing and turn to my fellow commissioners for discussion, questions, or a motion. Yes, sir. Commissioner O'Donnell. Okay. I have a question for staff. How tall is this house? Some people say it's shorter, some people say it's taller. I have an Exhibit 28 that I've been referring to, and since things have revised, I don't know if it's current or not, but it says the existing height is 25 feet. I'm not sure what it says. 25 feet, 35 inches? No. It's Exhibit 28, and the existing conditions, then it says the proposed package, and in fact, it would appear that both of them are over the required permitted height of 25 feet. Do we know how tall the proposed structure would be?
So in reference to the document you're referencing, there's 2 height requirements. There's a maximum height at any given point, and there's a maximum height low. So that's the 25 feet and 35 feet. So that's why you see the 2.
Oh, 35 feet, that's right.
For the maximum height to low.
So from the proposal prior to this one to the current revision, did the structure stay the same, get shorter, or get taller?
So on the elevations, sheet A3.1, you can see elevations there. Again, the individual elevation is the 25 feet, and then overall it's actually, I think, less than 35.
Okay.
So you can see those dashed lines on A3.1 of your plan sets. You should be able to see that how the house falls within those maximums.
I thank you for that. I have the charts, but I wanted to hear it from staff, because we've got people saying it's higher, it's lower, and I just prefer to go with staff's point of view, so thank you for clarifying. Other questions? Commissioner Hanson.
I actually wanted to ask the question that Vice Chair Kane asked me and that I asked earlier, in essence, staff, just to make sure that we're all, on this, or we're hearing the same thing. So the appellant's accusation that the house doesn't meet the grading and contours of the hillsides, staff didn't flag that in the report. So do you agree with that? Do you see any issue with that? I'd like to hear your thoughts.
So I'll jump in, and Sally obviously has more intimate knowledge, but generally that exhibit's used a lot for sites. We had a request to pull the house further from the creek bed, and so that was achieved, which did involve doing a more vertical cut deeper into the site. You also have to take into consideration the constraints across the contours and what the width of that house is. You can't have the house stepping down every 10 feet. So those challenges, we have to kind of weigh those, and that's something that the commission should weigh, and if they don't think it's appropriate, then that clearly can be the comments that are made. But those are some of the things we weigh in relation to that specific item, because this is a fairly narrow area in which the house is put.
Okay, that helps a lot. Can I ask a second question?
Yes.
About the trees, I think you'll say we could put it in as a condition, but I'm looking at supposing that we would approve this. I don't know if that's the case, but on the conditions of approval, the arborist requirements, it just says the developer shall implement at their cost all the recommendations, and the removal of trees and shrubs shall be minimized to the extent feasible. That makes me really uncomfortable, given the statements that were made about they're saying they're taking out 7, but they might take out a lot more. Can we actually put a limit on the number of trees that are removed?
You technically could. I think the challenge with any construction site, hillside or flatland, obviously there are recommendations from arborists of methods that can help ensure the life of those trees, but there sometimes are unforeseen instances. Removing a tree unto itself isn't an environmental impact. We have a tree protection ordinance that says if you remove one, you have to replace it to meet the canopy size or pay the in lieu fee. We could start there. The challenge gets to be what's that time frame look like?
I see there's unforeseen impacts, but supposing the thing that happens is not that the tree gets less healthy because it was just going to happen anyways, but we've heard this in some other cases where they actually go and just go remove trees, and then it's up for us to try and figure out what happened.
Sure. So, and I'm not sure if the town code has methods to remedy that. And so they basically will have violated the tree removal ordinance if they remove a tree that they weren't supposed to remove or didn't have a permit to remove. And so there are remedies in the town code to address that.
Okay.
And are currently taking those steps on other properties to levy substantial fines for trees that were damaged during construction.
Okay.
Other questions? Commissioner Hudas.
I had a few follow-ups to testimony that we heard. I guess first one's about driveway, and I wanted to understand staff's position and potentially the report. I think the MND, which is I think Exhibit 44, about the setback for the driveway. So first of all, is 20 feet the correct setback for the structure, and why isn't it 25 feet?
So, and we have Lisa Peterson, the town's engineer, here this evening also, who could speak to the grading and to these issues as well. But the 20 feet, again, as it was noted in the staff report, and I think in the M&D addendum as well, it's the town's discretion on the setbacks and development review adjacent to any kind of stream. And with a slope stability analysis, such as this case, that can be reduced. So our policies actually say that it would be 20 feet in the R1. 20 feet in the R1, and this is not in the R1. But nevertheless, given this is a residential district, even that 25 feet, which is what is looked at, could be reduced with a slope stability analysis. And that's what we have in this case. So that's for the structure itself. And again, I'm sure Lisa can speak to that as well.
Okay, well, that's satisfactory to me. I understand that. The second question is about the driveway. And why should that setback be 10 feet instead of 20 feet? Does it count as a structure? And, why is that okay?
Right, and so again, Lisa could speak further to that, but does not count as a structure. You can see in the guidelines that there's discussion about pathways, circulation. This wouldn't be a parking structure, I think, which was cited by the appellants. This would be a driveway on a single-family home. So I don't know if Lisa has anything more to add to that, but the 10-foot setback, as noted in the addendum, would be more than adequate.
Yes, Lisa Peterson, town engineer. Thank you. Yes, that's correct. So it's clear in our guidelines that actually specifically says that the roads can overhang and encroach beyond within the top of the bank. Now, additionally, it's also important to note that there was a slope stability analysis that was completed that actually did look at the road as a structure and made a determination that that was going to be okay as far as the slope stability. That was also reviewed by the town's geotechnical consultant as well, and agreed with those findings.
Okay, thank you. I had one other area.
One more, go.
This is the cantilever issue. Could you explain to me how the setback relates to a cantilevered building and where the proper measurement should be taken for that setback?
Again, I don't know if Lisa wants to add to this, but the cantilever, is she nodding?
Yes, thank you. Yes, I can respond to that. So we would not consider the setback from where the cantilever comes out to. It would be considered from where the structure is actually intersecting the soil.
And what's the reason for that?
It has to do with the loading, and you're not having additional loading that is, or substantial loading that is coming from that overhang. So you're really looking at the footing, and that's where the load is being transferred into the soil.
Okay, thank you.
Other questions at this time? Now, I'm going to suggest, because I've been requested to do so, that we take a 10-minute break, clear our heads, come back and get something done. We'll be back in 10 minutes. some 40 exhibits to this case. It's a complicated case. We needed some time to try to get our heads straight, but let us return now. Do we have it? Commissioner Hudis.
I'm prepared to make a motion unless other commissioners feel that there's more need for discussion or questions.
I would make my motion.
Okay. So I move to deny the appeal and approve the architecture site application S15077 for 19 Highland Avenue, APN 529-37033, and include the following actions to support the approval. First is to make the finding, the CEQA finding, that the proposed application is in substantial compliance with the CEQA review completed in 2010 and will be subjected to the mitigation monitoring and reporting program adopted in 2010, Exhibit 33. I would also add to that it needs to be in compliance with Exhibit 44 and 45, 45 being the addendum to the previously adopted mitigated negative declaration. In addition, I can make the finding that the LRDA exception is appropriate and the project otherwise complies with the Hillside Development Standards and Guidelines, Exhibit 33. And I can make the finding that the project complies with the Hillside Specific Plan, Exhibit 33, and also make the required considerations as required by Section 2920-150 of the Town Code for granting approval of an architectural and site application, Exhibit 33, and approve the architectural and site application S15077 with revised recommended conditions, Exhibit 26, and revised development plans, Exhibit 27. And I would add to that the town, in that conditions, monitor the development to ensure that the 79 trees that are existing shall remain in addition to the new trees that will be planted. So this has been a challenging exercise, particularly with regard to the LRDA. I can make the LRDA finding because I don't think there are other reasonable alternatives, and the LRDA exception is permitted when there are not other reasonable alternatives. I think that the factor is reducing the size of the house even smaller, but I believe that with the current version, we are presented with an application that is already more than 16% smaller than the maximum allowed, and also finds itself in the lowest quartile of FAR, meaning the smallest impact in terms of the ratio of the floor area to the lot. So I can make those findings with regard to the size of the property. With regard to the location of the building, I believe that the applicant has maximized the opportunity to step the home into the topography, and for that reason they have minimized the bulk and mass on a hillside. In addition to that, I don't think that the visual effects of this particular structure will affect others in the town very much. I also think that the applicant has gone to fairly great lengths in the architecture through articulation of the wall and roof planes to help reduce the building mass as well. So those are my reasons for the motion.
Did Town Council want to add an addendum to the addendum as was mentioned earlier?
No, he captured that language.
All right. Do we have a second? Commissioner Hanson.
I will second the motion.
Let us have discussion. Commissioner Hanson.
I thought Commissioner Hughes did an excellent job of summarizing most of the key issues. I just wanted to add on a couple. One of the most contested issues here was the CEQA, and I was happy that we had a chance in our workshop to go over the CEQA again. But the thing that resonated with me is that even though a number of years had gone past, this is basically the same type and nature of project. There isn't really that much difference, so it doesn't qualify as a new project, and that the existing conditions, nothing had really changed from the original project either. So I totally could understand the legal opinion that we got from our town attorney about why we can be comfortable with the existing mitigated negative declaration. And I further thought it was great that we have the addendum that kind of goes through the issues again and takes another look and says, here's where we are now and here's where we were there, and this is why there isn't any substantial changes. So I thought that was great. I would have hoped that there would have been more of a substantial reduction in the size, but I don't think that was the most pressing issue. And I concurred with the issue about the LRDA. Because of trying to be not close to the creek, you have a choice. You can be close to the creek or you can be close to the road, and that meant being further in the hillside. And I don't think that absent of reducing the size to a very, very tiny amount, that there would be a way to stay totally within the LRDA, so I feel comfortable with that.
Commissioner Erickson.
So this is undoubtedly a very challenging issue for the commission to consider, for the town to consider, and the commission acting on behalf of the town. It's a very challenging site. The town code, the guidelines that govern this particular site are intended to protect the interests of the town, but appropriately to give the deciding body some discretion when there are particular challenges. There were most of the challenges, many of the challenges that would face the deciding body came into play in this particular case. The appellants appropriately challenged us to think carefully about the decision, so I appreciate the fact that you did that. That's the best of decision making for the town. So we appreciate your doing that because you challenged us and challenged the applicant to sharpen our thinking and the applicant to sharpen their pencils. So I think that the process in this case worked, and I'll be happy to support the motion.
Other comments? I'll make a final comment. In 2001, roughly similar application, certainly the same property, came before the Planning Commission to construct a single-family residence. The Planning Commission denied the application, and the decision was appealed to the Town Council. The result of that was Resolution 2001-128, and the Council said, I think, some pretty important words. The project site is very sensitive in that the potential building area is very limited. A significant redesign is necessary to ensure that the proposed project is compatible with hillside topography and vegetation, and that the structure is compatible with the God bless you. Thank you. And that the structure is compatible with the neighboring structures in terms of mass and scale. I don't know that we've met those archived resolution guidelines 100%, and I don't know that we've that I'm satisfied regarding the appellants, pages 20, 21, 22, 23, 24, where they take excerpts from the Hillside Guidelines and say, do this, don't do that, and it's borderline. I hear staff's guidance, and I still have concerns about the three-story argument that we had, and I hear staff's guidance, and I'm still concerned about the seller arguments that we've had. But I don't think it's worth resisting at this level any further. There have been significant changes, and I appreciate that. I appreciate the work of the appellants and the outstanding letters, and somebody over there is a really good writer because it kept me up. But I'm likely going to reluctantly agree with the motion. Other discussion? Hearing none, I'm going to call the question. All those in favor? Aye. Opposed? It carries unanimously 5-0. Mr. Paulson, are there appeal rights?
There are appeal rights. Anyone who's not satisfied with the decision of the Planning Commission can appeal that decision to the Town Council. Forms are available in the clerk's office. There's a fee for filing the appeal, and the appeal must be filed within 10 days.
Thank you very much. Chair Badami, welcome back. Oh, hell. This has been a mess. I hope that's it.
Item number 4 is 210 Highland Terrace, architecture and site application S-16-015, requesting approval to demolish an existing single-family residence and construct a new 2-story single-family residence greater than 5,000 square feet on property zoned HR 2.5, APN 529-36-025. May I have a show of hands from commissioners who have visited the site? Any disclosures from commissioners? Commissioner Hudes.
I had incidental contact with, I believe, a tenant at the site, but I did not discuss the project.
I would also disclose that I also had incidental contact with a tenant while visiting the site. Ms. Armour, I understand you're providing us with the staff report this evening.
Yes, good evening. Good evening, Chair, Vice Chair, Commissioners. The project in front of you today is the proposal by H.Q. Shan to build a new 2-story home on his property at 210 Highland Terrace. The project is being considered by Planning Commission because the house proposed is greater than 5,000 square feet and located within a hillside zone. As described in the staff report that you received for this evening's meeting, the proposal is not the largest house in the immediate neighborhood, either by FAR or by floor area. The town's architectural consultant did review the proposed project and found that there were no concerns for compatibility or design. There was one element that was discussed in his report in relation to a concern that we received from a neighbor prior to the architectural consultant's review, which was expressing concern about the new 2-story home blocking their view from across the street and up the hill. In response to that concern, the applicant redesigned the house so that the second story was shifted to the side rather than being centered on the first floor mass. It was that design that was reviewed by the architectural consultant. After the architectural consultant's review, the house was actually further reduced in height by approximately 2 to 3 feet in order to make sure that it did meet the maximum height in the hillside zone. So then once that redesign was done, the story poles that are up now do fully represent the currently proposed project. The neighbor has since emailed staff to let us know that their concerns have been addressed. Staff recommends that Planning Commission review the findings and considerations in Exhibit 2 and consider approving the project with proposed conditions of approval in Exhibit 3. This concludes staff's presentation, but I'd be happy to answer any questions.
Thank you, Ms. Armour. Questions for staff? Commissioner Hanson, followed by Commissioner Hudes.
I saw that in the staff report that there wasn't any comments received, but was notification sent out to, I think that's typical practice, to the within 300 feet or 500?
Yes.
Or?
Notification was sent out to the neighbors within 500 feet of the proposed project. And the neighbors who had previously commented on the project, I specifically contacted them via email and asked whether they had any comments they wanted to provide to the Planning Commission.
Okay, and then just one other quick question. It said in the staff report that there's no trees to be removed. Is that correct?
The proposed building is predominantly in the location of the existing building, so yes, I believe there are no trees to be removed.
Okay.
Commissioner Hudes, followed by Vice Chair Kane.
In terms of the comments, in walking the neighborhood, it appeared that the neighbor at 209 and I think 207, or 205 rather, would be the ones that were impacted. Are those the neighbors that you received comment from? Because I don't think we had anything in our packet.
Correct. The neighbor at 209 Highland Terrace, directly across the street, is the one who expressed concerns early in the process, but did not provide any comments for Planning Commission.
Vice Chair Kane?
Am I mistaken, or did that neighbor have initial concerns and they used the visual showing the sight lines from the subject house to the subject neighbor's house, and he had concerns about the view? And if that's correct, is it not that the house was amended such that this neighbor was satisfied with those amendments? Is that correct?
In response to neighbor concerns, staff did request the elevation or the cut through of the building showing the adjacent property uphill that is included in the plan set. And it was in preparing that the applicant also redesigned the house so that a substantial portion of the two-story home was shifted out of the way of that view.
I have a thought while the question came up on the 500-foot notification. I visited the site, and it's way up in the hills. And I'm wondering, when we get up in the hills, is 500 feet adequate? Because they could be 1,000 feet apart on some of those sites up in them thar hills. Should we make that wider?
The policy that the staff uses for notification in the hillsides is 500 feet or at least 30 properties, 30.
Okay, last question. It is said that this case is coming before us because Section 9B3 of the Hillside Development Standards and Guidelines states the Planning Commission shall be the review authority for any residential project greater than 5,000 square feet in gross floor area. And I wondered why. Is that a presumption that something may be afoot? It's almost prejudicial, or is it supposed to be just cautionary?
So I'm sure Ms. Armour wasn't here when the guidelines were developed. I was, but I wasn't that deeply involved in them. I think there was a time where staff could approve hillside homes, and there was a time where staff couldn't. And then I think this was the next evolution of that, where if you have a hillside home that's less than 5,000 square feet, meets the guidelines, that's appropriate. But once you got over that threshold, the decision makers, either the planning commissioners at the time and or the council at the time, set that 5,000 square foot threshold that requires planning commission review.
So it's not to be prejudicial or presumptive, rather it's just cautionary that we take a look at it.
That's accurate.
Thank you.
Commissioner Hudes.
With regard to neighborhood compatibility, staff prepared the neighborhood analysis table on page 4, and I think the conclusion is that the residence would be the second largest in the immediate area. Now, I've noticed in these tables sometimes you include how many stories the buildings are, and I'm wondering whether that's relevant now. We're going from a one-story to a two-story building, and do you have any information on whether the immediate area contains two-story buildings?
I do not have that specific information in the report. That's the type of thing that is most relevant when you do have houses in close proximity to each other so that you're looking at one next to the other.
Okay, thank you.
Any further questions? Seeing none, I will now open the public portion of the hearing and allow the applicant and their team 10 minutes to address the commission. I have a speaker card from Michael Davis, so I'm assuming you're Michael.
That would be me.
Thank you.
Good evening, commissioners. I'm Michael Davis from D&Z Design Associates, the designer of the home before you. Wanted to thank Jennifer, first of all, for a concise report to all of you. She did help us through that process with the neighbors and the redesign twice of what we did. The neighbors were kind enough to invite us into their home and look at their view that they were looking at. Very early on in the process, we stuck a ribbon up there, not story poles, but a ribbon indicating the height of our house. And they expressed a concern right away. And so we changed it. The Pure Arctic came back and looked at it, and then they also had still a concern after we stuck the story poles up. So we actually redesigned it yet again, sliding that two-story portion of the home, which is only, well, less than 50% of the first floor, further over to the right behind the trees. I saw all the hands go up when the commissioners were asked if you had visited the site. You understand that the street is above the house, so we're kind of down in a hole. As you see, the design of the home, too, our second-level windows aren't looking over any of our neighbors either. We're very concerned with privacy. We have installed this house pretty close to the footprint of the existing single-story home that's there, including the driveway, which helped us keep all of the trees that are on the site now. I think the town arborist is requesting that we remove one plum tree. It's way up the driveway, so that can certainly be removed per the town arborist. But we wanted to keep all the trees on the site because that gave us screening, one, for all the neighbors, but also privacy to the home we've designed too. So all the trees stay, the driveway's in basically its current condition. The second level was reduced, as Jennifer had said, for a height issue, but again, it's been slid over a couple times. If I may, this kind of shows the evolution of the house. From the first design that you see up on top, and the massing kind of centered in the house in the first floor footprint. Then a second one, the first evolution of sliding that two-story massing over to the right side. Also, as you remember, it puts us more into those oak trees that are screening that part of the house. And then the lowest one is the two reductions of that second level, sliding it over. So the red that you see all the way to the left upper level, we reduced all that mass, and then that kind of orange color, that was the second iteration. They saw a ribbon on our height. They said, well, we'd be more comfortable if we moved it over. So we did that for them also. They wanted to see Levi Stadium. I don't know if they still want to see Levi Stadium right now, but that was the view they had, and that's what we retain on what you see before you. And I'm here for any questions. Again, Jennifer has hit all the high points for us. No trees removed, limited grading, footprint basically in the same part, and we keep the privacy. I did hear one comment about 2 stories in the area. Our next door neighbor is that largest 2-story, just to the right as you look at our site. I'm here for any questions.
Thank you, Mr. Davis, for your presentation. Questions? Commissioner Hudes.
Thank you, and I appreciate seeing the evolution and appreciate seeing the working with the neighbors to reduce the impact. The other question I have, when I'm looking at the rear elevation, I'm looking at a really quite a large mass and sort of a monolithic character, particularly to the left side of the building. That's the front elevation, but I'm referring to A5, the rear elevation. I was wondering if, 2 questions here. Have you sort of taken advantage of articulation in order to reduce sort of the monolithic appearance of that large mass? And the second question is this even viewed from anyone? Can you see this by neighbors? Can this be seen from the valley floor or from streets in the downtown?
We could not see the orange netting anywhere from the viewing platforms going to the articulation. We did slide all of this second level over to the one side of the home. So when we first designed the home, that massing was in the center. What we've done for articulation is there's 2 bay windows that cantilever out on that second level. Those are 2 bedrooms that has roof elements on them. Also on the lower floor, we've added a shed roof over our windows coming from the living room, and then that cantilevered balcony coming off the master bedroom. So not a continuous gutter line per se. It's broken up with varying wall planes along there. And also the angle does help too. As you remember, the carport angles as it exists today, we've kind of followed that angle too. But what we are blessed with on this is a lot of trees, whether they're oaks or other trees, screening this house from most all of the other properties.
Good. I appreciate that because it is difficult to pick up on the articulation from the elevations and the first and second floor plans. It's hard to match them up and understand that. So your explanation is helpful, particularly about the bay windows. Thank you.
Any further questions? Seeing none, you can stay there for just one moment. I'm going to look to the audience and see if anybody would like to speak on this item. I do not have any speaker cards, so I don't see anybody coming forward. So you actually have 5 more minutes to talk about your application.
I would look for an approval tonight after what you just went through. This seems a little easier for you all.
Vice Chair Kane.
I have a question. Let me get this straight. You were asked to reduce the height of the building, and you did. You were asked to move it over to improve the view, and you did. You're not going to cut any trees. You're using the same footprint. What are you really up to?
Well, my gray hair is 35 years doing this, so I try and work with the neighbors. And actually, my clients are here this evening. It is not a spec home. It is their home. The tenants are there until we start construction here. The neighbor up above, we realized early on that could be a concern. That's why we stuck that ribbon up there. I think we put ladders up there and poles and put a ribbon, and the neighbor had an immediate concern. They invited us into their home, so we're able to walk through each of their rooms. And their home steps down as we go along. If you look up at their house, it steps down as you look toward the right. So we wanted to retain most of that view. Now, if they... Go ahead, I'm sorry.
We're good.
Okay.
So, you haven't answered my question, but you're good.
Well,
no, I'm
maybe
kidding.
the owner
Thank
can
you.
stand up and answer that.
There's no reason to do that at this time necessarily.
Thank you.
So any further questions? Seeing none, thank you very much. The public testimony portion of the hearing is now closed. Do commissioners have any questions, comments, or a motion? Commissioner O'Donnell.
I have a motion. The motion would be that we find the proposed project is categorically exempt pursuant to Section 15303 of the California Environmental Quality Act. We make the required findings as required by Section 2910-9030E of the Town Code for granting approval of the demolition of a single-family residence, and make the findings that the project complies with the hillside development standards and guidelines, and the finding that the project complies with the hillside specific plan. We would also make the motion would include the making of the required considerations as required by Section 292150 of the Town Code for granting approval of the architectural and site application, and approve the architectural and site application S16015 with the conditions contained in Exhibit 3 and the development plans in Exhibit 10.
Do I have a second? Commissioner Erickson.
I'll second the motion.
All right. Any further discussion? Commissioner Hudes?
I'm definitely supportive of the motion. I did have 2 questions for staff. I don't know whether they are relevant or not. So the first one is about septic tank. Are there no sewers in this area for connection, and does it require a septic tank?
The project is on septic, and that is going through review with the Department of Environmental Health with the county.
So, and there's no opportunity to connect to a sewer there, is that correct?
I know that the existing site is on septic and that is how the county is proceeding.
Yeah, we don't have that knowledge, and unfortunately, Ms. Peterson left the building.
There's no sewer available to us. Septic was difficult.
Yeah, I'm the only in that area. There's no.
There's no sewer there.
Okay. I had one other question for staff. The street is very narrow. Are you comfortable with fire department access and turnaround? Are there additional requirements for that?
Fire department did review the project and did not have any concerns. Their conditions of approval are included in the conditions of approval.
Okay, thank you.
Any further discussion? Vice Chair Kane?
It's a lovely application, thank you. Obviously, for some lovely people, welcome to Los Gatos.
Thank you.
All right. I will call the question. All in favor? Aye. Passes unanimously. Mr. Paulson, are there appeal rights of the actions of the Commission on this item?
There are appeal rights. So anyone who's not satisfied with the decision made by the Planning Commission this evening can appeal that decision to the Town Council. Forms are available in the clerk's office. There's a fee for filing the appeal, and the appeal must be filed within 10 days.
Thank you. Item number 5, 15565 Camino del Cerro, subdivision application M-16-007, architecture and site applications S-16-045 through S-16-047, requesting approval to demolish an existing single-family residence, subdivide one lot into 3 lots, construct 3 new single-family residences on properties owned R18, APN 523-23-094. May I have a show of hands from commissioners who have visited the site? Any disclosures from commissioners? Seeing none. Ms. Puga, we're ready for the staff report.
Hi, good evening, Commissioners. The subject site is located on the west side of Camino del Cerro, approximately 330 feet south of Los Gatos Almaden Road. The 1.2-acre site currently contains a single-family dwelling, including several accessory structures such as a carport, a greenhouse, and a barn. The previous property owner used the property as both a residence and a nursery. The applicant is proposing to subdivide one lot into 3 lots. All 3 lots would continue to take access off Camino del Cerro and would meet the minimum lot area of 8,000 square feet, the minimum frontage of 60 feet, and the minimum depth of 90 feet. The project requires public improvements, which include curb, gutter, and sidewalk along Camino del Cerro. The applicant is proposing to construct 3 single-family homes with attached garages. Each home has a different architectural style, and a color and materials board is behind you this evening. While the proposed homes would be the first, third, and fourth largest homes in the immediate neighborhood with regards to square footages, the proposed and varied setbacks will help to reduce the visible mass of each home. In addition, due to the proposed large lot sizes, the residences would be the 6th, 7th, and 8th largest in the immediate neighborhood with regards to FAR. Staff recommends approval of the subdivision and architecture site applications based on compliance with the residential design guidelines and compatibility with the immediate neighborhood in terms of FAR. There is a desk item before you this evening, which contains an email received after the distribution of the staff report, which contains a letter of support from an adjacent neighbor. This completes staff's presentation. We are happy to assist you with any questions.
Thank you, Ms. Puga. Questions for staff? Commissioner Hanson, followed by Commissioner O'Donnell.
I had a question about the neighborhood analysis. I'm pretty sure I know what the answer is, but I wanted to ask the question anyways. That neighborhood, if you look at the 2, 2, and 5 that we normally look at, the 5 would be the condos across the street, and I know that you included the side street Maria Teresa Court in there instead because they were all single family houses. But I just wondered if that was the right way to look at it. I mean, it may be spelled out that way in the design guidelines, but I mean, that is their neighborhood. They almost the entire frontage of the east side of the street is that whole condominium complex. And so I just wondered why theoretically, why we're not considering that in our view of the neighborhood.
Sure, I do understand that. And like you said, staff has generally just used the single-family homes for a comparison. In addition, the homes across the street are a planned development, so some of those square footages may not be as comparable to a single-family home. In the future, it's something we can consider incorporating.
And then related to that, the only home right now in the immediate neighborhood is on the flag lot, which you can hardly see it. It's next door to the property to the south, and you walk there. The house that's most visible, it's behind that. Is that correct? That is the only house that would be bigger than these.
That's correct. The flag lot would be the largest.
Okay.
Commissioner O'Donnell?
I just wanted to see if my memory is correct, and I guess what you've attached would confirm that too. I was on the CDAC that originally reviewed this process, and my recollection was that they came in initially with 4 houses, and they did not all have access onto the main street. And so this has been a substantial revision and a reduction in the number of houses sought.
That's correct. So a previous iteration went to the CDAC in December of last year with originally 4 homes and then a half cul-de-sac bulb. And so the recommendation or the advice given from CDAC was to reduce the number of lots because based on that 4-lot subdivision, one of them wouldn't have frontage and wouldn't meet the requirements for a subdivision.
Thank you.
Commissioner O'Donnell, I also was on that committee meeting, and they did reduce the lots from 4 to 3 or the homes, and did address a lot of our concerns. I was pleased to see that.
And that reduction was what we suggested, as I recall.
Exactly. Okay. Any further questions? Seeing none, I will now open the public testimony portion of the hearing and invite the applicant and their team to address the commission for up to 10 minutes. I have one speaker card from a Melissa Leet.
So, good evening. As Jocelyn said, we're proposing the Camino del Cerro development is proposing to build 3 unique and beautiful homes on the old nursery site. Our aim is to, one of the distinctive features we believe about our project is that we are building homes that have a floor-to-area ratio of only 17%, which is significantly below the 40% allowed by our R18 zoning. And another distinctive feature of our project is that we have worked very hard to make the project compatible from a size point of view. And so our homes, which are all in the 3,100 square feet range, are smaller than the house contiguous to us, which is the flag lot. If you look at the project now, it detracts from the neighborhood. And our idea is by building these 3 homes with the distinctive architectural styles, we will significantly improve the street view. Additionally, we had a structure of condition report commissioned by 4X Engineering, who found that the property or the houses already on the property were past their economic life cycle, did not meet current zoning requirements, and indeed were a threat to public society. Right now, if you look down on the property, it's filled with a lot of, particularly the back end, a lot of refuse and shrub and debris. So our idea when building the project is that we are going to clear out the debris, but maintain a large unbuilt corridor in the back of the project, which, if you can see from the Google site, it very much keeps a lot of the open space that was available in the nursery. And so, in effect, assures for all our adjoining neighbors a lot of privacy, and also kind of creates a green oasis in the middle of the neighborhood. Another benefit of the project will be to eliminate this driveway along the north side, which now has become kind of a parking lot and has a lot of sheds and is quite unsightly from the street. Whoops, sorry. From an architectural point of view, we spent a lot of time studying the neighborhood around us and also using the guidelines to create homes that we thought were both distinctive but also very consistent with Los Gatos' very lovely architectural aesthetic. Our first home is a traditional home. Our second is in the farmhouse style. And then our third is a craftsman house, distinguished by its the siding. Our project meets all height and shadow requirements. And in the process of doing our approval, one of our neighbors, who is here tonight, had a lot of concerns about the project, specifically about how it would impinge upon the privacy of his backyard. We significantly redesigned the project, and we have now met all his concerns, and he wrote a letter in response to support the project now. The one thing we do want to reiterate, we've asked for no exemptions. The project meets every requirement. And so in conclusion, we really believe that we've created a project that will enhance the neighborhood both from an aesthetic and economic perspective. We maintain a lot of the natural setting of the land as it was when it was a nursery by keeping our floor area ratios quite low. We believe that we have created architectural styles that are very much in keeping with Los Gatos' aesthetic, and also that we've taken away from any feeling of it being a mass development by trying to very much make the houses as distinct as possible. And also, we feel like we solve the problem of having a very dilapidated house already on the structure, and we bring in product that meets all the zoning requirements. Thank you.
Thank you for your presentation, Ms. Leet. Questions? Commissioner Hudes.
First question regarding architectural style. Mr. Cannon, the consulting architect, had some recommendations. Were those recommendations incorporated?
Yes, every one of them.
Okay. I have other questions too, but I'll let other folks go.
Commissioner Hanson, and then we'll get back to you, Commissioner Hudes.
One of the reasons that we're seeing this is because this would be the first, third, and fourth largest house in the immediate neighborhood. And it's pretty clear in our residential design guidelines that we don't encourage that to happen. And then, given my comment, even though we don't consider in the neighborhood right across the street, you have condos which are clearly even smaller than that. And added to that, the town is trying really hard to make housing more affordable. And so obviously smaller houses are better towards achieving that objective. So did you consider any plan that would bring these houses more into compliance with the immediate neighborhood? I did a calculation, and excluding the current house, the average square footage of the immediate neighborhood is 2,600 square feet, and yet these houses are all over 3,000 square feet. So did you consider the possibility of smaller houses? I understand the lot sizes on the far isn't the issue. It's the houses relative to the rest of the neighborhood.
Well, when we first chose, the two issues affect our choice in terms of the house sizes. One is economic, because the general cost of land and everything else, there has to be a certain house size to actually make the project economical. But probably more importantly, at the time when we were trying to decide how big the houses we should make, we were looking at what the other house sizes were in the neighborhood, and we were trying to make sure that we would indeed not be the largest houses on the block. And at the time, we thought the flag lot, because it was our direct contiguous our neighbor would therefore be considered, but indeed, because it's set back, it isn't considered to be the largest house on the block. But at the time, we thought that was indeed a reference point.
Well, I think it is in the analysis that the flag lot is 3,272 square feet, and you would be, one of your houses would be bigger than that.
No, that's incorrect.
That's not what our staff report said.
Yeah, I think that's just a typo error. Our house is 3,193, not 3,390.
Thank you.
Commissioner Hudes?
I wanted to understand a little bit about what's going on with the placement of the house on each lot. And these are quite large lots, and it looks like the houses are quite close to the street with an enormous backyard. So is that one backyard for, I wasn't quite clear in your explanation, was that an open space to be shared?
No,
There's a fence that goes the full length of each lot.
Yes,
correct?
that's correct.
So they each have their own. Did you consider setting the houses back at all? And what's your thinking on placing them there, first of all, close to the street, but also it does appear that they are very close to each other, 16 feet wall to wall. And when you've got these large lots to work with, did you think about placing the homes so that they might be further back or not impinging on each other?
I think at the time we were designing it so that it met requirements. Would you say, I mean, I think we would be open to, if you would want to vary the setbacks a little bit more, I don't think we would have it, or to make them greater relative to the street, we wouldn't have a problem with that.
Well, I just wanted to know what your thinking was about it. I don't like to design things from here, and there's pluses and minuses to doing that. We have some residential guidelines that say that the building front's setbacks should be consistent from one parcel to another, but we also have ones that talk about articulation, and we also have kind of the unique situation here with those homes across the street that are placed diagonally, and so they don't have that, the condos, so they don't have that uniform setback. So I'm really kind of interested in, your thinking as a designer about why they are in line with each other and why you've got, these very sort of minimum setback from the street and enormous backyards. Does that make sense?
Well, we certainly thought that part of in designing the project, we thought that maintaining that unbuilt corridor and allowing for large backyards would be an appeal of the project. We had discussed before we switched the lots, we did have variation so that we had our middle house was set back an extra 5 feet relative to the others. And I do think actually, we definitely have room for more variation if we wanted to set back one house a little bit more than the other. But at the time, it seemed to be, when we first made the proposal, it seemed to be accepted by staff, and it felt like it was enough of a setback from the street, and that the condos across from it were indeed set back in itself, so that the structures would allow the maximum open area, but it's created enough distance from the street to be visually and aesthetically pleasing.
Okay,
Vice Chair Kane, and we'll get back to you, Commissioner Hudes.
I need a clarification. The staff report says that the houses are respectively 3390, 3200, and 3197. And in your presentation, you said that they were all in the range of 3100. They seem not to be, and then you said, well, no, that's a mistake. Those numbers are wrong. And since I'm sharing the same concerns of Commissioner Hanson, I think it's important we get a clarification on that. What are the sizes of the house?
So lot 1 is 3,193 square feet. Lot 2 is 3,200 square feet. And lot 3 is 3,197 square feet.
So did you reduce this? Can I ask a question of staff?
Go ahead.
I'm lost. 3390 versus 3191, which is...
Sure. So if you take a look at page 5 of the staff report. Pardon me, page 3 of the staff report under architecture and site applications. We discussed that the home is 3,193 square feet. However, they have 197 square feet of attic space. That, pursuant to the town code, is counted as FAR.
So the house is essentially 3190 for policy considerations, and that means I share the concern of largest house. So I would ask the same question that Commissioner Hanson may have. Would you consider modification? The houses are lovely. I have concerns about the flexibility on moving them more toward what our guidelines provide. Is that a possibility?
It makes the project definitely economically more difficult. I mean, a certain amount of, so I guess the answer is I would try to resist that, but if it were a condition of approval, I would try to accommodate it.
Thank you. And my other question is, would you put the houses back up again? I'd like to take a look at house number 2. That one. Is that the actual color you intend to use?
Yes.
Thank you.
Commissioner Hudes?
So I wanted to talk about the privacy between the homes. It appears that there are windows looking into windows when I look at the side elevations. I was able to count, I think, 9 windows or 11 windows on lot 2, which is the center house. I'm looking at the left elevation on sheet A10. Is that what is facing the fence and the adjacent home?
I'm going to have our architect, Doug Macbeth, come up and talk specifically about that.
All right, and as the architect is approaching the podium, I want to ask you to complete a speaker's card before you leave tonight and announce your name as well.
Hi, my name is Doug Macbeth. I'm with MGA Architects. I was the project architect, designer for this project. To answer your question on that particular elevation, to a certain degree, we do try to consider windows facing other neighbors. We do, to a certain point, try to have windows not line up with each other as best we can with the floor plans. But we feel like with the side yards that were 8 feet, with a total of 16 feet typically between these homes, that was a sufficient distance between the homes. But let me turn to that question that you had on lot 2. On the left elevation?
I'm looking at A10, the lot 2 left elevation.
Mm-hmm. The 3 larger windows on the second floor, those are high windows in the stairwell. So they're not actually...
Is there a seat there?
No. There is
not on that one? Okay. Because I know there's some seats.
They're clear-story windows in a two-story volume space. And the other windows on that wall plane are just small windows on a bed wall.
Okay, it looks like a lot of windows facing windows. Are you planning any kind of screening? Often we get some kind of design with this. And the reason I'm asking is that when we have applications for homes where there is an existing home and someone puts a house in with this number of windows on the side, we often get complaints. And so, particularly since you do have very large lots to work with, it seems as though we're potentially creating some privacy issues for purchasers of these very, very nice homes. So I'm just trying to explore whether there's been any thinking about privacy. It isn't just one window on a side here. We've got quite a number of windows on both of these homes, on both sides of the home.
Right.
So what's your thinking about privacy?
Well, I don't think that we have a lot of windows that look on the sides. I can kind of go through each plan and review that.
Well, am I correct that on A10, on the left elevation, there's 11 windows, and there's 9 windows on the right elevation, and that's the home that's in the middle?
Let's go through those here. On the, are you counting windows on both first and second floor?
Yeah.
Because we generally feel with the 6-foot-high neighbor fencing that anybody standing inside of a room is really not going to be looking directly into a house.
But you have second floor to first floor because you've got 2 stories next to each other, correct?
So, for instance, on the left side of lot number 2, we have 2 small windows that have a window sill that's about 6 foot tall in the master bedroom. So you wouldn't be able to look out those windows. The 3 windows in the stairwell are up, clear story windows up high just to get light into that space right there. So unless you're just kind of passing through the center hallway, you're really not going to be in a room looking particularly out a window. In bedroom 2, we just have a little small window looking out into the corner. All the other windows are clear story windows on that side of the house. On the opposite side of the house, we do have an interior bedroom that has just the 2 windows looking out to the side, but that second floor area is set back about 10 feet from the first floor. So we're not it's just not a 2-story wall. The other window is a high window in a shower, so the sill is about 6 feet as well. So we really don't feel like we have a lot of windows that look down into the neighbors on each side.
Okay. And are there any plans at this point for screening
You mean
between
like
the homes?
With trees?
Yeah. Shrubs, trees.
I don't think we have landscaping trees shown on the sides of the house other than on lot number 3, where there's some existing trees already along that side.
Okay, thank you.
Any further questions from commissioners? See none. Commissioner O'Donnell, sir, you can step back up.
Yes, I want to ask the architect. I'm certainly not going to try to design your building, but I'm just curious because you do have this great depth, and so it's really a question. It is not a suggestion, but you do have the ability to set back, for example, the middle home, which would address some of the concerns that Commissioner Hudas just raised, but I don't know visually or architecturally how much it makes sense to play with. In other words, you've got great depth.
Right.
But I don't know whether that means you could go back somewhat more on the middle one to deal with some of the issues of straight across looking, or whether that is something that's not done. So I was just curious as your thoughts on that.
Well, I know when we were developing the project and trying to place the houses, we did have a conversation about placing the houses back and trying to vary them. So they're not, the setback is 25 feet in the front, and plus there was if I'm clear on this, there was also an easement for the sidewalks that was attached to the property. So it added another 10 feet that pushed the setback, 25-foot setback back even farther. So we really kind of looked at where the garages were, because that's kind of what people look at when they see the houses, where the garages are, how they relate to each other. So we did push back lot 3 is farther back, lot 2 sticks out a little further, just to kind of vary that. And then the porches and the architecture goes back even farther. So they do vary enough where we felt comfortable with where they were. We didn't want to push the houses back too far, because then we felt like it would look a little odd in the general neighborhood, where the houses are kind of set back in a somewhat normal position, but we're another, we're up to like 35 feet in one of the locations on top of that easement that's allowed for the sidewalk. So we felt that was okay. So there is a possibility to, maybe take the center house and push it back a little farther, so the garage, which is the most forward architectural element of the three homes, would be set back farther. But we also didn't want to create these long driveways, which, just creates a lot of...
No, I understand that. And
yeah. So we went through that.
The garage would not really address the issue that was raised here. So, and I'm not saying this is something you should do. I'm just thinking out loud with you.
Right.
If it were to be set back additionally, it would be the windows that I would want to affect. The garage is not the issue. So, and I'm not telling you should do it. I'm just asking you about it.
Right.
And from the only suggestion you've given me at the moment is maybe you could do something with the projection of the garage, and that really doesn't, I don't think that deals with our issue.
Right. But when I did kind of go through and discuss the windows in the house number 2, I really don't feel like we have a lot of windows along there other than an interior bedroom that's set back from the first floor about 10 feet, that we've kind of kept everything, the windows really to a minimum on the sides, and kept high sills. Because generally, like in the master bedroom, we generally put a 5-foot tall window on either side of the bed, but we did want to keep the sills up higher and only put the 5-foot deep windows where we had to for a window for egress out of a bedroom. So.
All right. If I could just ask one question real quick, and then I'll get to Commissioner Erickson and Commissioner Hanson. And by the way, bear with me on this one, commissioners and staff. Is there a reason you did not include a cellar element?
A basement?
Yes, it seems like every application we get these days have a cellar, so I just would like your input as to why you chose not to include one.
It's interesting. We've just recently, we started doing a lot of basements. And it's all driven by economics. And it seems like in properties, for instance, in Menlo Park and certain areas on Peninsula that are really expensive, they need the square footage to justify the cost, to make the project pencil out. They need the additional footage. Basements are expensive to build. And that's generally why you don't see them. Only when they can really recover that cost through the market will they put basements in.
Thank you. More than anything, I was just looking for your professional input, so thank you.
I think every home should have, my family's all from the East Coast, and basements. Their garages are clean. There's just a car. There's not, my garage is storage, and my car is on the driveway. No, I don't. They do on the East Coast.
All right, Commissioner Erickson.
So well, I've heard the concerns about, I think you addressed them reasonably, and there's reasons for the setbacks and so forth. So I have a different question. And while I understand what I'm going to ask you about would suggest a longer driveway, but you chose an architectural style for at least 2 of the homes, if not the third, but 2 of them, where the garage becomes a prominent element of the facade facing the street. Mm-hmm. And one could, because they become a significant width of what is facing the street and are the closest element to the street. Mm-hmm. So one part of the town's residential guidelines suggests that garages shouldn't be prominent elements of the facade facing a street. So with the depth of these lots, you had an opportunity not to put where in other lots where you're more constrained with the depth of a lot, sometimes it's necessary to do that to accomplish. So I guess I'm curious why you chose the architectural style you did with making the garages prominent elements of the front, as opposed to other architectural styles which would have made them less prominent on the front of the homes, if you understand the architectural question.
Sure. I know that we wanted to have a 3-car garage for these homes, which is really what buyers are looking for. And so we wanted to avoid the 3-car doors in the front. So all of our garages are tandem. And so we felt like by just reducing that big 3-car garage across the front and just providing one small single garage door, that that we were doing that. Plus, these lots are deep, but they're not really that wide. The footprints aren't as wide as it kind of relates to the depth of the lot. So it would have been a little trickier to try to push get the garage farther into the back. So we felt comfortable with the garages the way they were.
Thank you.
Mm-hmm.
Commissioner Hanson?
So you answered part of my question, but I did notice when I first looked at this that not only are the houses the first, third, and fourth largest houses in the neighborhood, but the garages, all of them are quite a bit bigger than the other garages in the neighborhood. Maybe not substantially bigger.
Right.
So I just was trying to understand the justification for garages that are that big. I mean, do the other houses in the neighborhood have 3-car garages? I mean,
gosh, I can't answer that question.
And then tandem garages is not something I have seen in other proposals we've looked at, but maybe we haven't seen.
I think in all practicality, people rarely park the cars tandemly. That third space is generally used for storage. That's really why we generally provide a 3-car garage. It's so you can really park 2 cars in the garage, which is what most people have, and you get that third space generally is just used for storage, because that's really what's lacking in all the garages that we do in most homes. We do 20 by 20s, and that's always an issue, is storage.
Okay.
What are the dimensions then of this? If you normally do 20 by 20, what's the dimension of the proposed garages?
These garages, they all vary here. They're generally, the 2-car portion in the front is 20 by 20, and so there's between 18 and 20 feet additional in the tandem stacked area. So it's another.
I'm being a little dense tonight. Would you explain to me how that works? You got a garage door, and you can drive, I guess, 2 cars side by side into the garage, right? But you have room, theoretically at least, for 3 cars.
Right.
So
you'd
you
have
drive one car in first, and then
yes.
And where does it go?
Well, you'd have to move 1 car out to get the one in the back out.
So they come first stacked, one in front of the other.
Right.
Okay, so you'd have 2 in front and 1 in back, or vice
Yes.
versa?
You have 1 in back and then 2 with potential to go.
Okay.
Yeah.
I learned something.
But generally, it's used for storage.
I should have looked at your drawing.
Yeah. We put little cars in there so you can see how it works.
Commissioner Hudis?
I had another question about neighborhood compatibility, and that one of the other things we consider are the number of stories, and we start understanding the height. I don't know whether you've done the analysis. I don't see it on page 5 of the table. The other homes that are in the neighborhood analysis, are they 2-story as well?
Gosh, I know that the homes that are adjacent on our street scene, those are 2-story. I know that the track that is to the right is a mixture of 1- and 2-story homes.
That Maria Teresa Court?
Yeah, those are, as far as I know, they're a mixture of, they're all 2-story. Oh, they're all 2-story. Bill's from the neighborhood, so yeah, they're all 2-story.
Okay,
Yeah.
thank you. That's helpful. That's one of the things we need to consider.
Any further questions from commissioners? Seeing none, stay there for just one moment. At this time, I would invite any members of the public to speak on this item, but I don't have any speaker cards. Would anyone like to come forward to speak on this item? See no one come forward? All right. Please state your name and address and fill out a speaker card for us.
Good evening. My name is Bill Frangia. I live at 101 Maria Teresa Court. If you can pull up the initial view that has all 3, I can quickly point out where my house is so you can see what I'm talking about. The Camino del Cerro view.
The street view.
Yeah, the street view. Okay, yeah. So I live right here. And initially, when I was, Melissa's been great to work with, by the way. She and her team have been very helpful and have.
Take the mic with you, sir, so that we can hear you.
This is the first time I've been to something like this before, so pardon my, When I first came home a few weeks ago, this house was in place of this one. And this two-story structure was literally looking right down into my backyard. And I have a little pool here. My kids and I are in the backyard quite frequently in the summertime. So it was quite a shock to see the orange story poles right there, 8 feet from the fence line. So I came and met with Jocelyn a few weeks ago, and she put me in contact with Melissa and her team. And they did their rendition of the second house in place of the third, moved the wall, this wall over about 4 feet or so, and basically assured me that all these trees that are here would remain, well, a few of them would remain, and then replace them with like-kind trees and trees that would grow and be tall, you know, just like the existing ones right now. From our second-story view, with these trees in the way, we can't really see the Los Gatos Blossom Hill Mountains right behind us. If you take those trees away, then yes, we would be able to see that the second-story home, but it wouldn't be. I guess what I'm trying to say is, because this is here instead, it's a much better design than the initial home that was there. So I think what they've done is a good job. It's going to add value to the neighborhood and the existing homes that are all around our Maria Teresa Court. Like I said, they're all two-story homes. It seems to kind of mesh well with the other homes that are in the area. So I don't know if you guys have any questions for me as far as a homeowner in the area, but I just wanted to mention that too. Thank you.
Any questions for the speaker? Seeing none, we appreciate your comments. Thank you very much. At this time, the applicant is invited back to the podium for another 5 minutes to talk about their application. Okay, all right. And are there any questions from the commissioners? Vice Chair Kane, do you have a question? Yes. Okay, yes, please come back to the podium. And we have a question for you from Vice Chair Kane.
So the question is, Mr. Frangi's house, is his house the White House on the corner?
Yes. It's 101 Maria Teresa.
Right, okay. I better be careful what I say about white houses then. This may go back to at the approval of the CDC, but I would have some concerns about the compatibility of the color with the other two houses. And I'm not a designer, but as I look at the house on the left and the right, it just feels like the one in the middle might be out of sorts to some degree to be that color. So rather than belabor the point, I would just say that would it be okay if we just left that decision between you and the director of the community development to look at alternatives and options to that color?
Sure.
Okay, thank you.
Any further questions? Seeing none, thank you very much. All right, the public testimony portion of the public hearing is now closed. And I will look to the commissioners for questions, comments, or a motion. Commissioner O'Donnell.
I just had a couple of comments because both of us were on the CDAC on this, and also we had another. I can't remember precisely where it was, but we had another development in that area because one of the questions that came up was, well, are there 3-car garages around there? And so I had a couple chances to look at that because somebody said no, and I found that yes, indeed, there are a number of 3-car garages having really 3 cars. In other words, this is 2 cars with one in the back. These were 3 straight across. So this would not, I'm just saying that this would not be an unusual. In fact, it would be more narrow than the typical 3-car garage. I'm only saying that because I had occasion on 2 separate occasions to drive the neighborhood looking for that. So.
Any further comments? Commissioner O'Donnell is ready to make a motion.
Find it. Okay. All right. The motion would be that we would make the required findings pursuant to the guidelines for the implementation of the California Environmental Quality Act, project is categorically exempt pursuant to Section 15303. We make the required findings as required by Section 29109030E of the Town Code for granting approval of the demolition of a single-family residence, and the required finding that the project is in conformance with the residential design guidelines, and the required findings as required by Section 66474 of the Subdivision Map Act, and the required considerations as required by Section 292150 of the Town Code for granting approval of architectural and site applications, and approve the subdivision map application and architectural and site applications S16045 through S16047, with the conditions contained in Exhibit 3 and the development plans attached as Exhibit 9.
Do we have a second? Commissioner Erickson?
I'll second the motion.
All right. Any discussion? Vice Chair Kane.
I agree with most of what the maker of the motion said, but I'm going to put an accent grave on the cautions we have in the residential design guidelines regarding largest house. We have first place, we give up second place to a flag lot, then we have third and fourth. And I want to make the point that it seems to me we're changing the neighborhood. And the residential design guidelines, I think, would prefer that we don't do that. So whether it's a voice in the wilderness or what, for that reason, I won't support. I'm going to give credence to our concerns with largest house. We have next largest house, and I think it changes the neighborhood.
Commissioner O'Donnell?
I just want to say that while I'm normally very sympathetic to that, the reason I'm making this motion is because in viewing the neighborhood, I don't think that street is a normal street where you have a line of houses on both sides. In fact, you don't. You've got a condominium project on planned development. On another side, you've got this very unusual lot with a an older single-story house, barn structures and all that kind of thing. It's very difficult when you stand there to figure out what the neighborhood is. And that being the case, what we're trying to do with the idea of neighborhood compatibility is figure out what the neighborhood is. And when I stand there and I think of these three homes going in, I don't think it does any violence at all to the neighborhood as it exists. I think conceptually, I agree with the Vice Chair, but practically, I think it doesn't fit. So that's why I made the motion.
Commissioner Hanson?
I expressed this concern earlier. I feel that these houses are too big for the neighborhood. We only have the methodology that we have defined in the guidelines in terms of determining what to look at in the neighborhood. And clearly this is the first, third, and fourth biggest house in the neighborhood. And this is how neighborhoods change into other neighborhoods. And I appreciate Commissioner O'Donnell's comments about shaping the neighborhood, but we do have the stuff that we have to go on Maria Teresa and the couple of houses that are next door. And if you look at this, the biggest house that would be the second biggest house is 3272, and then it drops down. The next biggest house is on Maria Teresa, and it's 2756. So it's a fair amount smaller. It wouldn't make it impossible to do a 3 or 4 bedroom home. That would be very nice. I just think that this is setting a precedent that we don't want to set. So I won't be supporting the motion either.
Commissioner Hudes?
For me, this one is a concern enough so that I won't support the motion, but it is pretty close for me. So I was going to suggest that, if the house size were reduced a little bit, and if potentially a larger number of homes were looked at because of the unique situation where the 5 that we normally consider are replaced by condos, and looked a little bit more detail at the neighborhood, presented some data to us about the stories of these additional homes, I would be more comfortable in supporting it. I'd also like a little more thought about the color of the home and consideration about privacy for Lot 2. I feel that Lot 2, if we were brought that as an application, there'd be an outcry, and we'd have a hard time approving it because of privacy issues with the number of windows that are on that particular building adjacent to the others without a plan for screening or other privacy. And I think there are options that are available here in terms of maybe locating the house further back. I don't know if that's the correct thing to do relative to our design guidelines, but I don't want to design from here, but I think that some method for ensuring privacy of Lot 2 would be helpful and would improve this project. And also, I agree with Commissioner Erickson about the predominance of the garages. I think it would be worth, again, taking another look. I think we're fairly close on this, and I'm very appreciative that we're at 3 homes and not 4. But I won't be supporting the motion because it doesn't quite get over the edge for me.
Commissioner Erickson?
So I would say the applicant adequately addressed the issue that I brought with garages, so I think probably that I think this is the best design. For the frontage, given the limitations on of the frontage of a 70-foot wide lot, for me, I have to, so clearly we have guidelines and we are to follow them. If in fact we were to just prescriptively follow the guidelines, most of the things like this would be done by the staff. Our responsibility is to use some discretion, as we did earlier this evening. So for me, when I look at the neighborhood, and I happen to ride my bike a lot in this neighborhood because I live close to that area, so I have high familiarity with the neighborhood, but that's maybe not relevant. But you have a situation in town where you have a transition from a single-family residential neighborhood that you had a commercial property, you had a commercial enterprise in, and the street that these lots front on is in fact the boundary of that single-family neighborhood. And at some point, if you transition from a single-family neighborhood to a multifamily neighborhood, you're going to have a boundary. This happens to be the boundary. So at some level, what it looks like across the street is irrelevant to me in terms of thinking about the neighborhood, because this is the boundary of the neighborhood. The neighborhood, if I think about the residential neighborhood, and if I think a little broader than the typical, and I think I may have a duty to do this since it's on the boundary, then I think of the typical 9 houses that we do. And if one were to go broader into the neighborhood, easily these would not be the largest. There are other houses in that neighborhood that would make these not the largest houses in the neighborhood. There are 3-car garages that are not tandem garages in that neighborhood, in the residential neighborhood, that are there. And while certainly the houses, while these are larger than all the houses on Maria Teresa, these lots are all approximately twice the size of those lots in that. And they've been judicious about not pushing the envelope and putting as large a house as would be permitted on the property. They also did not propose to put secondary structures on them, which these lots could have easily supported. And so they chose to do some things that were reasonable, in my opinion, in the context of the lots, in the context of the neighborhood. They followed the direction from the town's CDAC to use 3 lots, not 4 lots. So they've done mostly what we've done. They've created 2-story houses in what is a predominantly 2-story neighborhood, no matter how narrowly you define it or how broadly you want to define it. So They've been respectful of the front setbacks, so they've not asked for any exceptions. So they have, in my judgment, done what the town has asked them to do.
So I concur with Commissioner O'Donnell and Commissioner Erickson for the reasons stated, so I will be supporting the motion. Is there any further discussion from commissioners before I call the question? Commissioner O'Donnell.
Well, if I can count, it looks like it's going to be 3-3. And I guess I'm just wondering, because Commissioner Huda said it was a very close question, and so I'm just going to ask this question, and that is, because I totally agree with Commissioner Erickson, and so that, this can be appealed, which I just assume we didn't have to pass it along, but is there anything that anybody can suggest we could do by way of amending the motion which would satisfy the commissioners who are not satisfied? Now, I realize some of you have said things which would be rather dramatic, so I wouldn't think that would do it. But I just throw that out because we can do the vote, and if it's truly 3-3, then it fails. And then we can look for another motion. I just throw that out as a question.
Commissioner Hudas?
Well, for me, I understand the arguments that have been made, and I'm lacking some of the data that tells me about, the homes with the 3-car garages. They don't seem to appear on our information, and because we applied sort of the formula for defining the adjacent neighborhood, we missed out on other homes that I would consider. I'd rather have information on what's on Edmund Drive in particular. There's only one house that's cited there on the table. And I'd like to see a plan for privacy for Lot 2. I really think that Lot 2 would not pass if someone wanted to build it in between Lots 1 and 3, because I don't think we've really thought through the privacy issues there. So I don't know that we can come up with a solution to that. And I'm not suggesting denial. I'm suggesting, in my mind, continuance to work on some of the things that are, in my mind, are close but not quite there.
I just offer a little bit of information. So on the Via or the Maria Teresa Court, those I just looked in Google. Those are all, I think, as Commissioner Erickson said, they're 3-car garages across the front. They're all, or if not predominantly, 2 stories. The house just to the left of the flag is a 3-car garage. It's not facing the street, but it's a 3-car garage across the side. And those are all 2 stories as well. Understand where your comments come from. And so it was a unique instance, and so that way it was a little different chart than you're used to seeing, as you mentioned before. But I think those are some of the factors, and so that's a very small portion of the information you were looking for, and not really concrete.
It's definitely helpful. It doesn't answer for me the privacy issue with Lot 2 and whether we've thought through the screening or relocating the house or dealing with the issues.
And I think the screening would be easily accomplished. I think the other thing to take into consideration, and you can feel free to disregard it, this is a unique situation. All 3 houses are going to be built. You're going to know what you're getting into. So it's not the same type of situation of when you come in with a house adjacent to an existing house and you have that conversation. I think it's been expressed this evening, there was a concern from one of the adjacent neighbors, and they've made some accommodations to address that. And so I think I look at it as a different situation than a house going in next to an existing house, because you're going to have all 3 at the same time, so you know kind of what you're going into when you decide to make that purchase.
Commissioner Erickson, followed by Commissioner Hanson.
So I have a question for Commissioner Hudas. So if, in fact, there was an amendment, and I'm not necessarily prepared to make the exact wording of the amendment, but if the essence of the amendment were to approve what is proposed with a I'm not going to say an additional condition, but with a kind of a rider on it, if you would, that directed the applicant to work with the Director of Community Development to address potential modifications to the design of the second house to address the privacy issues in a way that would be consistent with the concerns raised, and we left that to the discretion of the Director of Community Development. Would that be sufficient?
Unfortunately for me, it wouldn't, because there are many approaches to privacy, and although I appreciate that these three are being built at once, I think we need to respect future residents of the area and apply kind of the same standards that we would to other homes with regard to privacy. And I still have the concern about the data in terms of the size of the home. I'm not concerned that these are, vastly over the neighborhood, given the FAR that puts them in the bottom quartile of FAR. So I agree with that argument, but I would like to see a little bit of reduction in the house size and a more tangible solution for the potential privacy issues on Lot 2. Like I said, I think I'm close. I think this could be worked out through a continuance, in my opinion.
Commissioner Erickson, followed by Vice Chair Kane, followed by Commissioner O'Donnell.
So let me, I may be concerned that I wasn't clear about what I was proposing. I was proposing that we give discretion, administrative discretion, to the Director of Community Development to approve a different design of the home, of one or more of the homes, to address we would pass them with essence, but vest in him the authority to approve a different design, as opposed to requiring them to come back here, because my guess is that it's not going to be, my guess is that to address the privacy issues, they will not throw out I'm not trying to tell them I'm not trying to suggest what they should do, but I don't think they will throw out the present designs and start over. They'll do some, I would envision they would do some minor modification to address the privacy issues. So I was trying to give that discretion, let it move forward, but give the discretion to the administrative discretion to the Director of Community Development with an amendment. But that's not sufficient. That's not sufficient.
Well, for me, it's not, considering the outcry we've had over a single window and that type of thing. I'd like to see a tangible solution before I'm comfortable in supporting it. So like I said, I'm close, but I'm not quite there.
Vice Chair Kane?
Commissioner Hanson made the point, and I really didn't see it the first time around. The neighborhood, as defined by the report we've received from staff, averages 2,500 feet. That's a rough eyeball I just took, especially if you take out the hidden flag lot. And the proposals, given the benefit of the doubt, at 3,200, 3,100, I'm suddenly looking at the math that these new guys are 30% bigger than the old guys. And what I said earlier about redefining a neighborhood, I don't know. You got condos across the street, and now you've got three 3,200-foot houses in their face, and that's going to redefine their neighborhood. And it might not be positive redefinition. Now, I don't think it'd be the end of the world to get them more in line with the feeling of the existing neighborhood, in particular Maria Theresa Court, which is very, very nice. And I don't know that we've ever been persuaded by economic arguments before, because that's the only defense I heard for 3,200 square feet houses, and that's not my purview. So I think we could get an amendment along the lines of what Commissioner Hudis is suggesting, and get them down a little bit and make them more compatible with their surroundings. I hope that's not unreasonable.
Commissioner O'Donnell?
I think we've said everything we've got to say. I guess we should just call the question.
All right, I will call the question. All in favor? Aye. Opposed? Motion fails. Commissioner Erickson, Commissioner O'Donnell, Commissioner Badami in favor. Commissioner Hanson, Commissioner Hudis, and Vice Chair Kane opposed. So we will try another motion.
What it's going to be.
And I'm going to suggest that somebody might want to make a motion to continue to work on the items. Commissioner O'Donnell?
We seem to have a fundamental disagreement. One, guidelines are guidelines. They're not something you're bound by. That's why they're called guidelines. Two, this is not a normal neighborhood. Three, where we begin to differ, I guess, is our perception of what the neighborhood is. But if you believe the neighborhood is only as you look at it on this map and you didn't go out there, then I could understand. But I guess, yeah, we could send these poor people back, but I mean, it's like the windows. We've got 3 windows that are on the stairwell, as I understand it. We've got 2 small windows at 6 feet high. Then you come down to where the fence is going to prevent the view. So, yeah, you can say there are a lot of windows there. Now, what's the impact of those windows? Virtually nothing. Anybody that buys that middle house is going to know exactly what they've got. I'm very sympathetic to both arguments. I think we have to be very careful to not change neighborhoods, and I've been doing this a long time, and I've watched neighborhoods change that I didn't agree with. So I'm on an unusual position here. But I think what we got to do is let it fail, and they can. I have to look to guidance, I guess, from the town attorney. If you can't pass a motion, it fails.
Correct.
And I assume at that point they can either go back to the drawing board and do whatever they want to, or they can appeal it. Is that correct?
Continue the application with specific direction.
Commissioner Erickson.
Let me just say that the direction we've given them so far, to me, is incomprehensible. So that's what I'd worry about.
Commissioner Erickson.
So while I share the concern in principle about not letting neighborhoods change, this in reality is a built-out neighborhood, absent these 3 parcels. So at some level, and I don't mean this irresponsibly, whatever's built on this is not going to set a precedent for changing the neighborhood, because it's not going to have any impact. No one's going to go in given the age of the houses in there, the odds of someone going into this neighborhood and tearing down one of the houses given their ages and replacing it is not very great. So it seems to me the hypothetical concern about the fact that if we allow larger houses in this area, that it will change the nature of the neighborhood seems to me to be a purely hypothetical argument that wouldn't stand the test of time. The real practical stand the test of time.
Thank you for the comments. I am going to look to staff for a recommendation as to how to proceed at this point.
So you have a couple different choices. You do have a planning commission member that is absent, so it could be continued till she's back for the full discussion. Or you could make a motion to deny the project so that the appellant has that final decision to move it on. A tie vote is no decision whatsoever, and we don't like to have those. In that case, if there's no tie vote, usually what happens is you wait for the 7th person to come back. And if that's unacceptable.
I don't think she'll be back until December.
I would be happy to have her here. On the other hand, we don't want to be unreasonable in delaying this project, although hopefully we're moving into rain, so I don't know if we're really delaying the project.
And that doesn't necessarily mean that come December, one of the other members might not be here.
That would certainly change the vote.
Well, there's just a lot of what ifs. Commissioner Hudis.
I'm going to just try a motion here. I move that we continue the application to a date certain with direction to make a small reduction in the house size, or to provide data that shows that the house is compatible with the neighborhood. Secondly, to address the color issue with the middle house, and to have the opinion of staff on the appropriate color for that house, and to come up with a privacy plan for Lot 2 that we can review, that is a tangible plan for dealing with potential privacy issues.
Commissioner O'Donnell?
That may be the right way to go. I just want to ask a question about the continuance. As I look at the calendar, we have one meeting in November, and we have one meeting, I believe, in December.
Yes.
So we either continue it, if my eyes aren't as good as they should be.
And let me just confirm it's the 8th and the 14th. That up there is wrong.
Okay.
Well, I've already
So
made
my
that
eyes
mistake
are not
once
so
with an
bad.
item that's going to be continued, so you guys won't have to come. So,
Okay, so, but we can
And I
continue
will-
it to the 8th or the 14th, is that right? To say nothing of December, but.
So so your three choices again is if in fact there's no other future motions, that it is a denial, and the applicant would have the ability to appeal that. The second one is to continue it to a date certain with direction or no direction because you're waiting for your seventh member.
Well, yeah.
We do have a motion by Commissioner Hudes. So
We have
do
a
we have a second? And I think Commissioner Hansen has her hand up.
I'm willing to second the motion.
All right, so now we have discussion. Commissioner O'Donnell.
Okay, and as I said, I think that may be the right way to go, but then the question simply becomes when, and we have the argument that the faster we can do it for them, the better, but the other argument is that if we had a full deck here, it would be better, because it wouldn't be even. Whichever way it went, it wouldn't be even. But as Commissioner Hudes, I think, or somebody pointed out, there's no guarantee you're ever going to have 7 of us here at the same time, although we're usually pretty good at that. So the reason I'm asking all this is we're either going to continue it to one of those dates in November, which is fine with me, or on the assumption that our other commissioner will be back, and I guess we don't know this, at the first meeting in December. Do we know, have we gotten any word on that?
we don't have direct confirmation yet, but that's my assumption at the moment. The other challenge would be trying to continue it to the 9th. We'd be getting a staff report out next Thursday.
Well, the second date in November is...
There is no second date in November.
Oh, that's right. It's Thanksgiving this year.
Yeah.
Okay. My tendency, again, that seems unreasonable to staff. My tendency then would be to the only meeting in December.
Commissioner Hudes.
What is the date for the December meeting?
December 14th.
14th. Is there room on the agenda for this item?
Unknown at this time.
There might be.
But continued item would be first.
Okay. So that would be part of my motion, is the date certain would be December 14th.
All right. And Commissioner Hansen, is that a good second for you?
Yes, it's a good second. I had a comment after.
Go ahead.
Okay. Just in terms of what Commissioner Hudes said about it being close, I just did the math without having a calculator, so I might be a little bit off. But just to put the number on in a playing field, if the houses like the 3,200 square foot house became a 2,700 square foot house, that's only a 13% reduction. It's not. I don't think that's unreasonable. So that's kind of where I was thinking. I'm not putting that number out there as we can't do that. I'm just saying what the math was on that. That it's not a huge reduction. So.
Okay, so hopefully the applicant is looking to the direction from the commissioners. Commissioner Erickson?
So would be okay with continuing the item, but I can't support the motion since it includes direction to reduce the house, because I don't see any necessity to require them, to give them direction to reduce the size of the house.
I agree with that.
Okay, so, all right, any further discussion? Vice Chair Kane.
I'm so confused. I thought the issue was leave them as they are or reduce them, and the motion is to reduce them. And, I said these houses are 30% larger than the houses that are there. And Commissioner Hansen said, she gave some direction or number, they're 30%, cut them to something that fits in with the neighborhood. And I think for me, that's the only problem. And then we'd have a win-win, hopefully. So I would support the motion.
Commissioner O'Donnell.
Well, I was going to support a motion, I still would, for continuance. But I agree with Commissioner Erickson that it's very easy to say it's only a 13% reduction, which you multiply by 3 lots, so it's a 39% reduction in dollars. One of the questions is, what's the neighborhood? Some people are saying, well, the neighborhood is what the guidelines say, and that's clearly not necessarily so. So maybe we need some input on that. But I would not support a motion that tells these people they have to reduce the size. I would certainly encourage them to consider that, because it's clear that at least 3 of us would like to see it reduced. But 3 of us were not on that page.
Commissioner Hudes?
If I recall my motion, it was to reduce the size a bit. I didn't specify a number. And in consideration for what that reduction should be, I'm also weighing the fact that they're in the lower far quartile, which means that they're on bigger lots, and so I wouldn't see them having to reduce all the way to the size of some of the other ones. So I'm looking for a small reduction. But the other part of my motion was to provide data showing that these are in fact compatible, since we have a unique situation where we can't look at the houses across. So let's widen the net a little bit, look at some of the other homes, particularly on Edmund Drive.
If that's the motion, I could support
and
that.
so that is part of my motion. I believe that's what.
On the same page?
Yes, I was just going to make that comment that the way I heard Commissioner Hudes' motion was that there was a small reduction in size, or provide justification for the existing size by a different neighborhood analysis.
Okay, I'm not sure that'll be satisfactory for Commissioner Erickson, so would you consider inserting the word encourage the reduction, a slight reduction of square footage, because it may be different when we have 7 commissioners here as well, whether or not they take the advice or not. And Commissioner Erickson can pipe in if he likes.
Well, if I can count, it becomes maybe irrelevant.
Okay. All right. Vice Chair Kane?
I appreciate the effort, Commissioner Hudes. You're a nice man. I do not want to ignore the planned development condominiums across the street. That's what's in here. That's what's bothering me. 3 castles across from the condos. Those people are what's bothering me. I'll probably get over it, but right now, that's the way I see it. That is their neighborhood, and I'm not sure what's right. I just know that we have some language to support what we're concerned about. We have standard and guidelines for a reason. Maybe this is one of those reasons. Maybe this is what happens when we perhaps capriciously change a neighborhood. It's not good for everybody who lives there. So a slight reduction would certainly seem fitting. And you've given a way out with evidence to testify to whatever, but it better be from Supreme Court.
Yes, we can call the question. All right. We have a motion by Commissioner Hudes with a second by Commissioner Hansen. We've had enough discussion. I will call the question. All in favor? Aye. Opposed? Commissioner Erickson opposed. Passes in favor by a majority. That would be Commissioner Hansen, Commissioner Hudes, Commissioner O'Donnell, Vice Chair Kane, and Commissioner Chair Badami. Mr. Paulson, are there appeal rights on the action of a recommendation? Actually, this isn't a recommendation. It's getting late. Are there appeal rights on the actions of the commission on this item?
There are not.
All right, thank you. Mr. Paulson, do you have a report for us this evening?
I do not.
Do any of the commissioners have any matter to bring to our attention other than the general plan committee meeting tomorrow night? Seeing none, meeting's adjourned.